Yes.
Well, I want to make a mention in connection with serial number 6 in the cause list. Your lordship will recall, my lord, we have come against an order rejecting our petition under order.
I remember.
My lord, we in the meantime we filed the appeal under 43 against the status quo order. So that is not on the list. That is not on the list. If whether your lordship would like to take both the matters together or something. We filed on 20th against the status quo order that was in the suit.
So you got a status quo there in the trial court.
We didn't get, they got the plaintiffs got
in trial court.
Yes, yes.
So against that, the appeal has been filed. The appeal is not here before me. Okay. Yeah. Have you made a mention about that appeal memo of the appeal?
Yes.
You are mentioning the appeal today.
Yes.
We will then pick up the appeal on, but you cannot mention it before me. You have to mention it there. So, okay, you mention it there. Okay, let me have it on, then I won't take it up. Then let it go on 2nd of April.
What we matters to them?
I won't say that.
Yeah, yeah.
I don't know.
Yes,
as of now.
yes,
Not on 2nd of not on 2nd of April.
Oh, you are there. Fantastic. Okay. He's already there. So you serve him a copy of the memo of appeal, then we take it up both.
So in fact, we have filed an additional appeal.
Okay. But you want to appear now in the appeal?
Want to appeal in the appeal? We'll serve you a copy.
After 4:30.
Because I remember this case, if I'm not wrong, that was a case pertaining to wherein Mr. P.C. Goswami submitted that you are only taking action against that loan which was mortgaged.
Which was made collateral.
They are taking advantage of some internal communication and they have taken a status quo. Yeah, I remember that. Okay, Mr. Dekka, you are going to appear today in the appeal.
Hello, the appeal I'm not aware of it.
They'll give you a copy, you will appear today. Then we vacate the status quo order.
And I haven't been served with the copy, so
Okay. Okay. Mr. B.D. Goswami, the learned counsel appearing on behalf of the petitioner, submits that an appeal has already been filed challenging a status quo order, which is, however, not listed. Mr. B.D. Dekka, appearing on behalf of the respondents, submits that an additional affidavit has been filed, which is yet to come on record. Taking into account the above, lists this matter on 4th of April.
Lord, with the
copy is to be served.
But which one?
The condemnation in you.
It's not, appeal is not before me, na? He has only said it.
Ends your obliged.
Lord, with the consent of the other side, items 15 and 16, I seek some accommodation, my Lord.
So you are yet to recover from your leg fracture?
For 2 weeks, Lordship will accommodate me, my Lord. Then I will physically come down and do these matters, my Lord.
Which one, 15?
15 and 16, my Lord. I have taken the consent of Ms. Bhattacharya for the other side, my Lord.
Yes, I
Mr. A. Ganguly submits that he is indisposed on account of his leg fracture. Therefore, seeks for an accommodation. Into account the above, let this item be listed again on 7th of April 2025.
Lord, instead of 7th, can it be 8th, my Lord?
Why 8? 8 is a Tuesday.
My Lord, or then 9th. Lordship will kindly have it on 9th. 7th had some difficulties there, my Lord.
9th of April.
Lordship.
Lordship,
Both of them.
Both the matters.
I would like to mention 2 civil IOs for listing.
Don't mention it here. Go before the other court. I can't give you.
I'm mentioning this RSA before your lordship as because your lordship directed me to take trustee charges. And thereafter the appellant
The matter
instructed.
listed, madam, before me. Earlier is different. Now is it listed? I can't help you. Go there. There, you have another court.
Okay. Yes, yes, sir. Lordship, with regard to item number 47, I have filed an affidavit,
40?
47. That may be for,
Service.
for Dusty, I have filed an affidavit.
Yes.
I'm paying for listing of an FAO, my lord.
Who did?
Listed before your lordship on Friday last, but because of the bank was not available, the matter could not be listed. The last order. says
Whatever
for
may
the-
be, Mr. Prasad, the thing is, you cannot mention it before me. I don't have the jurisdiction.
May I please? May I please, lordship? Lordship, I beg to mention item number 35 to 44. Lord.
Why?
In this matter, lordship, this.
I asked only one simple thing.
Yes, lordship, we have
That's all.
applied for it, but yet not received.
These are questions not of stay. We are not concerned with the other side. Here, these are questions where these, what you call the reference proceedings have been put to stay.
Yeah.
On the ground that at that point of time, that court did not have the jurisdiction. Now that court has the jurisdiction.
Applied for the order.
Not necessary. We'll take it out. These are questions not of stay. We'll take it out.
Lordship, I need to pay before the item number 51, Lordship. Lordship, when the matter was listed on 17, Lordship, I was directed to file the amended cost title by 19, Lordship. Lordship, I was suffering from high fever, due to which
Item number 51.
51, Lordship. I could not submit the amended cost title, Lordship.
You could not submit?
The amended cost title, Lordship.
Can't help it. What to do?
I beg to pay before your honor, Lordship, to allow me to submit the cost title by.
There's a counsel appearing on behalf of the petitioner in person submits that on account of certain personal difficulty, he could not submit the memo of parties. He submits that he may be given another 3 days' time in that regard. Taking into account, let this matter be listed on 21st of April 2025. In the meantime, the fresh memo of parties be filed before the registry.
If you mentions. Your Lordship, I'd like to mention item number 34, Your Lordship. 34.
34.
Your Lordship, in the last order, this court has directed us to take the service of notice upon the respondents to trustee services. Your Honor. We have completed trustee services. We have filed an affidavit. I humbly pray to bring the affidavit on record.
You have a affidavit filed?
Yes, Your Honor. Oblige.
I thank the Lordship. Lordship, I beg to mention item number 23 of the daily cause list. Lordship, the original title suit has been compromised between the parties, and as such, the CRP becomes infractious, so it may be withdrawn.
Your name?
P. Agarwala,
You're not there.
petitioner.
You are not there in item number 23. Your name is not there. Ask anybody who is there when a matter is called. Yes,
Item number 35 to my lord, 44. Lordship, the matter pertaining to my lord, where the jurisdiction is there. Lordship directed us to produce the certificate.
forget about that. This is not the case where you are going to get a stay out here. These cases are required to be dismissed. On the ground, now that court has the jurisdiction, let the court proceed with the reference proceedings. Maybe at that point of time, it may not, but now, just for example, if it is returned and returned to where? Now, don't come up with all these cases. These are
Lordship,
finished.
can you see that
Mr. Ramane, at the end of the day, your client is going to suffer.
Right.
If it by any chance the amount goes higher,
Right.
then who is going to pay for the interest? These are things which I think being a counsel of
Right.
a long tenure out here, you should withdraw. This is a thing. Because as of now, just for example, this court today holds that yes, as on that date, the court did not have the jurisdiction. Fantastic. So what do this court do? Return it to be filed where? To the same court now. It is this reference is
Yes,
being
sir.
made by
Practical
that
question is that,
particular
sir.
officer to him. We'll look at when the matter is
Fine,
taken.
fine. Item one item is item 23, your lordship. Actually, there is a compromise between two parties titles to matter. This matter will be withdrawn, your
Your
lordship.
name is there?
Yes, your lordship. J. Das.
The J. Das, the learned counsel, appearing on behalf of the petitioner, submits that as per his instructions, that he has been instructed by the petitioner to withdraw the instant petition. Taking into account the above, the revision petition stands dismissed, stands closed on withdrawal. Full stop. Interim orders, if any, stands vacated.
But okay.
On item one.
Yeah, please, your lordship.
Yes, what is this?
Yes, lordship. Your lordship, the cause of action to prefer this civil revision petition at page number 33, your lordship. Here, your lordship, one petition under section.
What are you challenging, madam?
Lordship.
What are you challenging?
Yes, your lordship. The rejection, your lordship, to impede your lordship to the seeking whereby the police aid was sought for, your lordship. To maintain or to impede or implement the status quo order, your lordship, passed by the civil court of Nagaon, your lordship.
You have not deduced evidence.
Your lordship, one civil nazir was appointed, your lordship.
Understood. He goes out there and finds out that there is nothing out there.
Your lordship, there is no opportunity has given to educe my evidence, your lordship. We have just filed the section 151 petition before the court of civil judge Nagaon, your lordship, senior division.
No, no. Did you file an application under Order 39, Rule 2A?
Lordship.
Did you
Oh,
file?
yes, yes, we have.
Which
filed.
one? Where is that?
It was lordship, that was rejected also. We have preferred an appeal, your lordship, before the district court of
No, no, no. Against an order under Order 39, Rule 2A,
lordship.
I don't think there is an appeal provided.
Yes, lordship, 2A is there. We have preferred the petition, your lordship.
Huh?
We have this preferred the petition also because the status quo order has been violated, your lordship. On the occasion of
No, no. Violation is different.
lordship,
Against the violation, have you taken any action? I'm asking you that.
we have preferred an lordship 39 to a petition, your lordship.
You have preferred then?
Order 39 rule to a petition, your lordship.
Then what else?
Violation, your lordship.
Hmm.
That was also rejected, your lordship.
That was decided against you.
That was rejected, your lordship. On the same ground, your lordship.
Okay, then
To not
then
reduce-
that appeal is pending.
appeal is pending, your
So
lordship.
how do you maintain this?
Your lordship, that is the another aspect, your lordship. When your lordship, my prayer is that your lordship, as your lordship 47 of the Assam Police Act, your lordship, have framed some obligation to the police, your lordship, to protect the property in the states, your lordship.
Madam,
Lordship.
when there is an injunction order, you say that it has been violated,
Valid.
for which you have gone and filed an application under Order 39, Rule 2A.
Lordship.
The learned trial court holds that the application which has been filed under Order 39, Rule 2A, rightly or wrongly, is rejected.
Exactly.
So there is no violation as per the learned trial court.
Lordship.
Now, this is pending in an appeal before a court. Once it is pending in an appeal, where the learned trial court is of the opinion
Lordship.
that there is no violation, then can this court, under 227, in this proceeding, which is the proceeding actually not under Order 20, order under Section 151, but is in the spirit of Order 21, Rule 35, pass an order? Tell me.
Here my, your lordship, the prayer, your lordship, under section 151, seeking police aid, your lordship.
Why you are not filing an application before the appellate authority,
Have filed,
before the appeal? No, you have filed an appeal.
lordship.
So why you are not filing an application there also? That kindly look here, kindly give a direction to the police. Why you are coming here? Are you not, therefore, can this court today come up over here when the learned trial courts, the order is already there in another proceeding where it says that there is no violation? Can this court, wouldn't it be two forums exercising the same jurisdiction?
With due respect, your lordship, and to my understanding, your lordship, actually, my prayer is little bit different, your lordship. Order 39 rule 2A, your lordship. It will take time to lordship, to lay evidence, your lordship, everything.
But that has been dismissed.
It was dismissed, your lordship.
So therefore, you have filed an appeal.
Filed a
The appeal is pending.
pending.
So when the appeal is pending, why you are not filing an application there? What you are trying to do, on one hand, you are assailing that order under Order 39 Rule 2A, where the trial court said that there is no violation. The matter is pending in an appeal. Now here also, this court is going to look into as to whether there is a violation or not. Now, can the court, when there is, or now, just for example, if I say today, let the police help be given. Tell me, how do I give it when there is already an order being passed by the learned trial court that there is no violation? You get the point? So why are you not filing an IA there in that appeal? Then look here, this is the violation for which I filed an appeal. There was no opportunity being given to that effect. So under such circumstances, I am before you. Now, along with that, so kindly see that now this order is still there. The order of injunction is still there, but they are violating, so kindly direct the police. So why you are not filing an application before the appellate authority?
But lordship, what I thought, because there is no appeal, the order has been not appealable, your lordship. The order under section 151, the rejection order has been not appealable, your lordship.
This is okay, not appealable.
Lordship.
There's no quarrel with this. But the fact that if an appeal, if it is not, you have filed an interlocutory application. Now, this interlocutory application having been rejected, this is an interlocutory application in that particular Order 39 proceedings. So in that proceedings, Order 39 Rule 2A, already order has been passed that there is no violation. Now, how do I interfere out here and say that there is a violation? Tell me, can I today say that, okay, you are allowed to give evidence in a matter which the learned trial court has already dismissed it, which is pending in appeal? Would I be not exercising an additional, unnecessary, I will put it, a jurisdiction out here? You do one thing. You withdraw this, I give you the liberty to file an application before the appellate authority. Appellate court shall consider your application when you file. I think that is the best way out. I have heard Ms. So-and-so, the learned counsel appearing on behalf of the petitioner. First, the instant application under Article 227 of the Constitution is filed challenging an order dated 6/2/2024, whereby an application passed in Ms. case number 65/2023, arising out of Ms. J case number 25/2022. Full stop. Full stop. From a perusal of the said order, it is seen that the learned trial court, that is the court of the Civil Judge Senior Division Nagaon, had rejected the application filed under section 151 for police help. Full stop. At this stage, it is relevant to take note of that against the violation of the order of injunction for direction with a injunction for maintenance of status quo, the petitioner herein had filed an application under Order 39 Rule 2A alleging violation to the order of injunction. The said application filed under Order 2039 Rule 2A was rejected by another order dated 6/2/2024 by the learned trial court. Against that, the petitioner being aggrieved by the said order, the petitioner had already preferred an appeal before the which court?
Stick to your lordship, Nagaon. Nagaon, your lordship.
Before the learned district judge, Nagaon, wherein the said appeal being appeal number,
It's not me, your lordship, right now.
Huh?
Appeal number is not with me right now, your lordship.
appeal, wherein an appeal has been filed before, which is still pending. Full stop. Considering the above, comma, it is the opinion of this court that the exercise of jurisdiction under Article 227 of the Constitution in respect to the order dated 6/2/2024 in Mizze case number 65/2023 would not be proper. It is the further opinion of this court that the petitioner would be well advised to file an appropriate application before the appellate authority wherein an appeal is pending against the rejection of the application filed under Order 39 Rule 2A, if so advised.
For admission item 2, part heart.
Oh, you are there. What has happened? Now, what is this, Mr. Gogoi?
Lordships, they are not within the considered term of section 2, subsection 52 of the Local Act.
What does it require?
Lordship, paternal uncle or aunt, maternal uncle or aunt, paternal grandparents and maternal grandparents. They are the relatives under the definition of JJ Act.
They will get it.
They will get it.
See the juvenile justice act.
JJ, juvenile justice.
Now, have those people come up before you to seeking adoption custody? Mr. Gogoi, you have to understand, this person concerned, whose child it is, is on account of, I think it's a rape victim, isn't it? Isn't she a rape victim? That woman, whose child it is. Can you hear me? Can you hear me? Can you hear me or not? Who can adopt? Let's see the section. This will be not covered under the Hindu Adoption Act.
Probably they are applying before the board.
Understood?
No.
The board is there.
No.
There's no quarrel with that because the board has taken over the custody of the child. But how are you maintaining the child properly? Are you giving them the proper facilities? Do you have the resources for that?
Otherwise, enjoy proceed, take with the lawsuit.
No, I don't understand. When there is a parents, two person who otherwise have, if they have the resources out there, they are coming forward to take the benefit of the, take the child into custody, adoption. Should be the unnecessary problem. Unless your adoption board has found out somebody better than them, do it. There's no quarrel with them. We are concerned about the welfare of the child. We are not concerned with the parents. But the fact that whether you have anybody better,
Directed that far.
no, it is not a question of direction, but do you have anybody better? That is the only issue out here.
Otherwise, it is under the lawsuit, the NGO.
Huh?
That child is under the care and protection of the NGO.
Is the NGO in a position to give a very good care, which the parents would have otherwise given, who wants to adopt? If it is not so, then how do you take care of it? Yes, Mr. Sahu, please come here. You be the counsel for the petitioner. Come here, Mr. He will help you out. What is required to be done, he will help you out. Mr. What has happened here? This child, respondent number 7, is a lady. On account of, I think it's a case of rape, a child was born. Now here the petitioner number 1 and 2 wants to take the child in adoption. The child, after he was born, was taken away by the respondent authorities. Now he is under the custody of some NGO. Now he is trying to get it by applying. There's some problem in which the applying has been done by the petitioners. They are not providing the proper financial certificates on all these things. In spite of this court going on or giving an extra hand to the counsel for the petitioner to that effect that you kindly do, will take care of it. But then also they are not filing those 3 affidavits. Kindly help out this counsel for the petitioner what is required to be done. And Mr. Gogoi, don't take this to be an adversarial type of litigation.
That part not there. Even paramount welfare of the child is proceed.
We are concerned with the child.
Got
The mother, that is the respondent number 7, has no objection. Okay. Now, if you are going into a very hyper-technical thing, then you are to give us a best option as to who should be the child's.
That part is
Okay.
there. Otherwise, proceed the paramount welfare of the country.
You are concerned about the child. And the child is at a very nascent age. What is the age?
Now, his attendant is 1 year, 5 months.
This 1 year file.
They fulfill that particular condition. Madam, may kindly pay last paragraph also. They have failed to file that party affidavit of prospective adoptive financial and social status was provided so and so. If they can-
Consent of the biological parents for the country relative adoption of so and so. Here the respondent number 7 has no
that
objection.
part I have. Otherwise,
As mentioned about the relationship of the prospective adopted to the related family tree as per section 2B is also not provided. That can be dealt with. Only thing is number A has not been done. Mr. Sahu, kindly help here. I'll put your name as an amicus out here because the counsel for the petitioner is not going to help, is of no good.
Otherwise, PNC losing may waive.
Well, no,
that
only,
possibly-
only worry is if you can provide a better parent, you have it. But if you cannot, and if they have meet other criteria, don't be so technical in this regard.
That part I also.
Earlier, I asked Mr. M, who was that?
Mr. Setia is there.
Mr. Setia was there earlier. So and because of that, I have asked them to file the application in here. It is 1 year, 9 months, the child is. 1 year, 9 months, now it is 12 years, 2 years now.
I have no problem. if you
Is
see-
the adoption process going to finish up when she becomes around 18? No, I am asking.
That part is there. Otherwise, Lordship.
Even I won't be there.
PNC Lordship, it can be waived, Lordship. That financial status and
Financial status now.
that part is,
All documents are submitted by.
No, 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 no,
that
no.
part is
Whatever may be, you,
that part is.
Mr. Sahu, I am appointing you as an amicus. Look into this, talk with Mr. Kogoi and along with Madam, inquire, ask them, Madam, you go and inquire out there and find out what is actually required, what type of certificate is required to go ahead, give the certificate and then things will move. This is not going to happen in this.
One copy.
And don't come up with this thing, I have given anything. It has to be to the satisfaction of the authorities. If you are saying that, no, I have given, then forget about this. Why should I be care about that? Let this, I should issue rule and have this matter to be listed after 6 years or even 18 years. Then the question of adoption does not happen.
May I please, pray to, a physical appearance of child, my lordship?
Where? No, absolutely no.
That part.
That is not necessary.
Lordship.
We are concerned out here why you are not filing your documents properly. That is why I am having an amicus out here. Mr. Sahu is going to help you out, do what is required, and then we'll have it out. Mr. Sahu, kindly help this.
I will also supply one. copy
Yes,
to
yes,
Sahu.
kindly, Mr.
sure.
Gogoi, don't take it.
Lordship.
I'll put your name
My
out there.
intention
And
is also, Lordship, the interest of the child. the term
yes,
interest
we
of
are
the child.
concerned with the interest of the child. If the child can get it into the good hands of a
Lordship,
adoptive parents, it is
Lordship,
well and good.
Lordship.
Pursuant to the order dated 10/2/2025, Mr. A. Gogoi, appearing on behalf of the respondents, have placed before this court an instruction issued by the PO cum District Child Protection Officer, Kamrup Metro, dated 18th of March 2025, wherein it has been mentioned wherein the status report of the PAP, apostrophe S, PAP all caps, sir. Mr. PAP, Mr. Nipen Sarkar, Miss Yusa Pal, carrying registration number RSA S 202-501-069-719 under the relative adoption in Kara related to child named Uday. It is seen that the report was submitted. It is seen that the information is based upon a report dated 6/1/2025. Be that as it may, this aspect of the matter be that as it may, the said report is that pursuant to the said report, this court had already passed orders on 22/1/2025 and 10/2/2025. Thereby granting leave to the petitioners to submit whatever is required to be done. First, from upon hearing the counsels and from the report so submitted, it seems that it appears that there is some missing link for which the adoption process is not fructifying in the manner it should be. This court, for the interest of the child, that is Master Uday, is of the opinion that appointing an amicus in the instant matter would be in the interest of justice. Accordingly, this court appoints Mr. S. Sahu, the learned counsel. This court had requested Mr. S. Sahu, the learned counsel, as to whether he would like to assist this court in the matter, taking into account the well-being of the child. Mr. S. Sahu submits that he would be ready to assist this court. Accordingly, this court appoints Mr. S. Sahu as the amicus curiae in the instant matter. First, the registry shall provide the orders so passed in the instant proceedings, as well as copy of the pleadings to Mr. S. Sahu within 4 days from today. First, this court further directs both the learned amicus curiae, the learned counsel appearing on behalf of the petitioner, and Mr. K. Gogoi, the learned counsel appearing on behalf of the respondent, to talk it out amongst themselves as to what proper steps are required to be taken so that the interest of Master Uday can be well protected. Pursuant thereto, after such discussions, the petitioner shall do the needful, and more particularly, submit the required affidavits pertaining to affidavit as provided in Schedule Roman 24 of the Adoption Regulation 2022. This matter again on 23rd of April 2025 for an update. The registry shall show the name of Mr. S. Sahu as an amicus curiae in the cause list. Yes, please. Mr. Gogoi, I trust you. I think you will be able to.
Other part.
And so Mr. Yeah, and Mr. K. Gogoi's name. Good.
Other part
I
what-
want Mr. Gogoi, you appear out there in this matter so that we bring it to the level.
We can provide the lordship that particular, I can get there itself. I can.
Item 3, part heart.
But last quarter, I was directed to open instruction by what the amount regarding the structure. Malad that it is, Malad, he told me that within Malad 1 hour, Malad, he will send the Malad.
as to whether the petitioner is entitled to any amount on account of structure, and if so, how much? We have not got the instruction.
We already been communicated on 6th. The certified copy is on.
One judgment of the Honorable Lordship judgment is there. On PH, I have gone through the judgment, 2022. FCC online, Guwahati 240.
What do you
Your
say?
Lordship has decided what is the scheme of this act, 3H, 3H5, all it has been determined by this court. The only what your Lordship was asking them to get an instruction, that what is the, I'm entitled, whether I'm entitled to get the amount, so for this structure is concerned. And it's really saying,
Understood, but the fact remains that you have to do something as regards the withdrawal of the reference.
that's right, my lord.
Because there only you could have got anything.
But what is the withdrawal was done by Kala? Because my lord, the.
Understood, you have to
Yes,
challenge it
Lordship is
somehow.
right. Lordship is right, because why we were not receiving the land and whether Virat. That is why it was sent it to the district and session court to decide this. In the meantime, we came to the court only basis of structural compensation not being paid. Subsequently, when the matter was pending before this court, then, my lord, we decided to get that particular the value of the land, El Girard, that was paid. So they said that it has been paid. Your whole case of sending for reference was only because you are not accepting the land as well as the Girard. Now you have accepted that. 30 lakhs has been accepted. You have accepted
No,
that.
then if you are entitled to any further amount on
Yes,
the structures
structure,
which you
yes.
are not being paid, then you have to go under 3G5.
That's the what your lordship has decided. Yes, I have looked into it. Only my humble submission, because your lordship has asked for instruction, that whether I'm entitled or not. What is the amount? Suppose they said that I am entitled to get 20 rupees. I'm saying that no, I'm entitled to 50. So I will definitely go by that. That's there. Absolutely no problem like that. Your lordship has already decided. I have gone to the judgment.
Hello? But why should I give it as pattern? I'm not holding up this bench. Pattern. Mr. J. Hendrick submits that the instructions put forward by this court on 3/3/2025 have not yet been received. It seems that though this matter was being taken up earlier by this court from time to time, and as this court is presently not taking up this roster, it would not be proper on the part of this court to continue to monitor this litigation. Accordingly, the registry shall list this matter as per the roster. The records which were produced by Mr. J. Hendrick is returned and shall be produced on such directions being passed by the court subsequently.
I'm with you.
Public.
Item 4.
I pretty lot, my lord. My lord, as per the order of the court, my lord, steps was taken. And my lord, presumption was taken that notice duly served. Till date, they didn't appear, my lord.
What are you challenging?
Challenging is the, my lord, we made an application during the pendency of this suit as defendant, counterclaimant. My lord, to appoint an commissioner, to determine, my lord, the dispute, spectrum of disposition. Court kept the matter pending. Court says at this stage it is not appropriate that the evidence of PW be conducted. Then evidence was over, my lord, and we also adduced evidence. Then subsequently, my lord, on 11/4/2019, my lord, we made an application with reference to earlier application. The court has passed an order. Court kept the matter pending to consider in appropriate stage. Now court is saying that, my lord, since the evidence is over and matter is ready for.
No, evidence is over is not the question. The
That is the
suit,
point. That is the
no,
order.
Mr. Kukas, the suit is fixed for judgment.
Yes, yes.
Yes,
Yes,
not
but-
evidence, arguments
Evidence.
over.
Therefore, my lord, we made an application, my lord, that there is a dispute regarding possession. You are saying you have been disposed. I am saying I have been disposed. Therefore, unless and until it is ascertained who is in, my lord, which portion of the land or from which portion of the land, my lord, either of the party was disposed. If that fact is not decided, then how decree can be possible? And court is not even in a position to ascertain, my lord. Court didn't say anything regarding that evidence is sufficient or adequate. Initially, court said that not at this stage. Subsequently, court said evidence is over, matter is at the stage of judgment. Therefore, court is not in a position. And on the other hand, court has arrived at a purpose finding, saying that, my lord, the appointment of a commissioner cannot be an evidence collecting machinery. It is absolutely wrong. my lord.
That is absolutely right.
But there are some decisions on this point.
There are many decisions of the Supreme Court otherwise also. Wherein it says that it is not for the court. When the court finds on the basis of the materials are insufficient for
Right.
the purpose of passing a judgment,
Right.
then only the court will.
Then what is the finding, my lord? What
That
is
is what the judgment is.
there is no reason of this, my lord, to that extent.
Order 22/9, order 26
Doctor,
June
kindly
9
see
only
the
comes
order.
into play then.
Kindly
Why
see-
didn't you file this application earlier?
Kindly have a look, my lord. The imprint order. First order, my lord, I am referring to page
How many orders you have impugned? Only one.
only two orders.
Which two?
1911, 1911, 18, and my lord, 11/4/19.
What is 1911,
I am
2018?
referring at page 66.
Why will I look into a 1911, 2018 order?
Because, my lord, court kept the matter pending for consideration.
Huh?
Court kept the matter pending for consideration.
Which one?
1911.
So and so, so and so.
I am just reading, my lord. 1, 2, 3, 4, 5, 6, 7, 8, 9. From bottom. This court, therefore, keep this open for consideration at appropriate stage. This is the finding. And subsequent, my lord, by subsequent order, court has abruptly come to findings that it is at the final stage of
What
argument.
does it say about that application? What is there? It appears, therefore, this court therefore keeps this open for consideration at an appropriate stage.
Appropriate stage.
So thereupon, at the time of judgment,
Yes.
you wake up
After conclusion of evidence,
and argument. Evidence and argument.
Yes.
Everything is done. When the court fixes the matter for judgment,
yes,
then it is being done.
question is, my lord,
Oh,
what
we
at
forgot.
any stage. The word used is, my lord, at any stage. Appointment may be made.
What
at
about
any
the
stage.
other side? What has happened?
So there is no appearment.
Okay. Then you pay this 25,000 to the legal service authority. They allow it with 25,000
It will be too much, my lord.
to the legal service authority.
Yes, I am ready, my lord, 10,000.
Okay. Well, you have already stalled the suit for the last 6 years.
And the court did not pass an
So
interim
I
order. Court said,
just put it, Mr.
court said,
Mr.
don't
No,
deliver the judge.
Mr. Pukasta, I
Well-
put it 5,000, 4,500 per year. Which makes it 25,000.
My lord,
It doesn't look so nice.
my lord, Roshi kindly see. Court did not pass an interim order. Court has said, don't deliver the judgment. This much.
You have stalled the proceedings for the last. 6 years.
Court, my lord, COVID-19.
Are you in possession or dispossessed?
Number one,
Are you in possession or dispossessed?
matter is pending, my lord. Court is pending.
No. Are you in possession or dispossessed?
Some portion, my lord, I have been disposed.
But you have a counterclaim.
Yes, I have a counterclaim. And I made a specific, my lord, prayer. Appointed, my lord, commission for local inspection.
Okay, 25,000. Legal service. authority.
My lord, I'll also kindly,
And that day I saw a judgment of the Supreme Court that when this amount is being here, I will put it in a different manner now. So here, nobody will know whether you have deposited or not.
my
So
lord,
we
I,
will ask the collector
Well-
to use it as if you don't pay this amount within 20 days from today, shall be collected, recovered from you as areas of land recovery, land revenue, land area, And accordingly, if it is not paid, the matter will be placed before
Yes.
this court and I'll direct the
I'm
collector.
going to make a commitment, my lord, definitely I will look into it and
Okay, we allow it 25,000 cost.
as subject to
All
payment
good.
of, lord, kindly consider my prayer. I'm not bargaining, my lord. 20,000.
Okay, 20.
Okay.
But Mr. A.K. Pukasne, the learned counsel appearing on behalf of the petitioner. The supervisory jurisdiction of this court has been invoked to challenge an order dated 11/5/2019, whereby the learned trial court had rejected an application filed under Order 26, Rule 9 for the purpose of appointing a commissioner. To measure the land of the counterclaim, which is more particularly described in Schedule C to the counterclaim. Schedule C. Schedule C to the counterclaim, which have been,
That
from
number
which the
2,990.
counterclaimant was dispossessed. See, page 70, see the issue number 3. Is entitled to recover khas possession of Schedule C land as described in the counterclaim.
Madam,
So it will be, you have been, so you wanted the measurement of that.
madam.
It is seen from an order dated, it is seen that a similar petition was filed. Oh, no. It is seen from the materials on record that a petition number 989 under order 26 rule 9 of the code was filed before the trial court. For issuance of a commission to measure the suit land. To ascertain the real dispossession of the suit land of the counterclaimant by the plaintiff. By the plaintiff.
Principal, there are other persons, principal defendant number 1 and legal years of performer defendant number 2 and 3.
For issuance of, for measurement of the suit land, for ascertaining the real dispossession of the suit land of the petitioner herein by other defendants, by the petitioner herein, who was a defendant in the said suit, by the other defendants by issuing a commission. When the application was taken up, well, the application was filed at the time when the suit was fixed for evidence of the defendant witness. At that relevant time, when the said application was taken up on 19/11/2018, the learned trial court observed as the evidence of the defendant oblique counterclaim, the claimant is yet to be completed. It would not be safe to decide at that stage whether appointment of Amin Commissioner to measure and ascertain the alleged dispossession is necessary or not. It was categorically observed in the order dated 19/11/2018 that a court, therefore, that a learned trial court, therefore, would keep the issue pertaining to appointment of an Amin Commissioner open to be decided at an appropriate stage. The record further reveals that the suit was that upon the evidence being complete and the arguments were heard and the suit was at the stage of judgment. The petitioner herein, who was the counterclaimant, filed another petition being petition number 420, thereby drawing the attention of the learned trial court that the issue pertaining to appointment of an Amin Commission, which was there in petition number 989 dated 12/9/2018, is yet to be decided. And therefore, requested the learned trial court to decide the said aspect first before delivering any judgment. Because it is very pertinent to also to take note of that on 11/4/2019, the learned trial court not only rejected the application under Order 26 Rule 9, that is the petition number 989 dated 12/9/2018, but framed additional issues on the counterclaim. Issue number 3, which was framed on 11/4/2000, 11/4 or 11/5?
11/5.
11/5, na?
Yes.
It was framed on 11/5/2019. Agote a order challenging the order dated 11/5, huh? Issue number 3, which was framed as an additional issue on the counterclaim on 11/5/2019, reads as under, inverted comma, whether the defendant oblique the counterclaimant have right, title, and interest over the Schedule A land, and whether they are entitled to recover class possession of the Schedule C land as described in the counterclaim.
My lord, I'm sorry, my lord, 11/4.
No, see the next page.
Next page 11/5. A certified copy 11/4.
Huh?
I don't know, it is the title. That was 11/5, next page 11/5, but first page, earlier, previous page 11/4.
11/4. Mr. A.K. Purkasthar, the learned counsel, appearing on behalf of the petitioner, submitted that a perusal of the impugn order would show that the learned trial court did not give any reasons as to why the appointment of an Amin Commissioner was not required, except stating that the commissioner, that the prayer for local investigation cannot be entrusted to the commissioner to gather evidence for warranting survey of the factum of the defendant number one's alleged dispossession as prayed for. The learned counsel, appearing on behalf of the petitioner, drawing the attention to the issue, additional issue number 3, submitted that how would the learned trial court decide the issue number 3 which is as regards recovery of possession of the Schedule C land without there being a report of an Amin commissioner. First, this court having taken note of the order dated 19/11/2018, as well as the 11/4/2019, including the framing of additional issues on the counterclaim, and more particularly the issue number 3. And the fact that there is a dispute as to whether the petitioner herein, who is the counterclaimant, have been at all dispossessed from the Schedule C land described in the plain, is of the opinion that the learned trial court ought to have allowed the said application seeking appointment of an Amin commissioner. Accordingly, this court interferes with the order dated impugned order dated 11/4/2019 only to the extent whereby the petition number 989 dated 12/9/2018 was rejected. This court allows the petition number 989 dated 12/9/2018. This court further allows the petition number 989 dated 12/9/2018 and further directs the learned trial court to appoint an Amin commissioner to submit a report. It is further observed that on the base upon the report being submitted, the respondent, the learned trial court shall proceed with the adjudication of the said suit in accordance with law. Taking into account that there is a stay of the proceedings of the suit proceedings, this court of the suit proceeding, is there a stay? Where is the stay?
There is no stay, but direction was given not to deliver the judgment.
Where? No stay. It has been informed that this court duly takes note of. Last of all, this court duly takes note of that by an order dated 17/6/2019,
17/6.
an order was a direction was issued that the learned trial court may hear the arguments in title suit number 28/2016, but shall not deliver the judgment. This stay proceedings, this interim order had been continued since then. Considering the above order, the counsel appearing on behalf of the petitioner herein, who is the defendant, who is the counterclaimant, is directed to appear before the learned trial court on 23rd of April 2025 and produce a certified copy of the instant order. On the basis of the same, the learned trial court shall pass an order appointing directing the pass an order giving effect to the order passed by this court, thereby allowing the petition number 989 dated so and so and seek a report from the revenue authorities. The learned trial also, as the other respondents are not represented before this court, the trial court shall also issue notice on the same date for the appearance of the plaintiff as well as the other defendants in the suit, other parties of the suit, so that the suit can be brought to the logical conclusion, taking into account above the instant petition standards. No question.
Annexure C of counterclaim. Annexure C of counterclaim, not plain.
I know.
Annexure C of counterclaim.
Annexus C to the, schedule C to the counter.
How come? Schedule C of, yes. Schedule C.
No cost, no cost.
No, plus. Grateful, I'm grateful.
Item five.
Yes, what is this? What are you challenging?
Of the specific relief act, yes, it was decreed, my lord, against that, preferred this revision.
Why?
My lord, on the ground of perversity as well as the decision which has,
Has the record come? Record not called for.
it has not yet been admitted.
Not yet admitted. No, notice has been issued.
Yes, notice, they appeared.
Stay has been granted. You are appearing. Position has been stayed. So. What is the perversity?
Perversity is that, my lord, the plaintiff who are claiming that they are in possession prior to the disposition, that was not proved. Because in their statement, as well as in evidence, it has come to that.
No. First tell me. When did they file the claim petition? Claim suit?
6/9/2014.
6/9/2014. Okay. And that means they have to show that they were in possession within 6 months.
Yes.
So that is Seven, 3/2014. Isn't it?
And number 2.8,
So from 7/3 to 6/9. Is that finding there of the learned trial court?
their statement in the plain that
Coming to the fact of this, alleged that he was not present on remand as he went to Dimapur, but he returned in the evening and found the defendant illegally trespassing to the suit land and assaulted his mother. So the dispossession is on 31/8.
but in the plain as well as in the evidence, it is admitted from the plaintiff that pro forma defendant number 20 and 21, from whom they purchased this land, they are in permissive possession. Not the plaintiff. Number two,
No. Tomorrow my tenant,
not tenant, my lord.
no, or permit, or if I allow somebody else to reside out there in my house and you take over the house out there, is that person going to file the suit or anybody else?
No. With respect to pro forma defendant, they were the owner, original owner. And number two, on the basis of the sale deed, in the sale deed, my lord, in the northern and southern portion, there is a road in between my land and their land. But when this suit has been filed, that road has been included in the schedule, my lord. That is one of the aspects, my lord.
No, we are not concerned whether we are not concerned. Let us not go into like a normal suit. The simple question is, were they in possession of the suit land and did you dispossess him? So means whether they were in possession of the suit land as on 7/3/2014, and after that, did you dispossess him without due process?
There is no finding.
There is a finding. There is a
There is a
finding.
finding, but that is perverse, my
And
lord.
why you are saying it to be perverse?
Kindly see page 47. Page 47. And in this land, my lord, when my
No,
Part is there.
these judges, they are writing long judgments unnecessarily. This is the only issue.
Only
Now
to
kindly come to paragraph 28. In the light,
my lord,
let me analyze the case. The schedule in question has been already mentioned. The plaintiff alleged that they were dispossessed from scheduled land on so and so. The initial burden rests on it to show his possession over the suit land. Has to stand on his own legs. So and so it is when the issue in a footlet. He stated that he purchased the suit land by the registered deed dated Kiman from performer defendant and in possession and is in possession since then. Peruse the text receipts issued by so and so. On perusal of the sale deed which have been submitted in the thing that original so and so with the fact of possession. The plaintiff entered into possession on 16/8/2014.
my lord, may I say one, there are
According to
one
the facts of the
paragraph,
case,
my
the plaintiff believes that he was not present in the on the suit. Wasn't there?
my lord,
Matter over.
my lord, kindly see paragraph 24.
What is there? No case, no
Peruse
case.
the evidence of PW2, PW3 and PW4.
Peruse the email.
They corroborated the version of PW1. In cross-examination, PW2 stated that 200 number so-and-so has been damaged by the defendant. PW1 was not present on that day of occurrence. In cross-examination, PW3 will substantiate the documents submitted by PW1. PW4 is the pro forma defendant number 220 and of the vendors of the plaintiff who stated in cross-examination that on 16/8/2014, he executed deed number so and so in favor of the plaintiff, where he has given northern boundary is house of Liaquat Ali. But in fact, in the northern boundary is the lot of Liaquat Ali, my lord. He
I am
has
not going to look into all those things.
He has not, my lord, kindly, next
This
para.
is the finding of fact is not there.
He has
I'm-
not
No,
executed the
Mr.
grant of aforesaid part.
No, Mr. Ghosh.
My lord, what
No, no.
will happen, my lord? Suppose this, my lord, this
He
is,
purchased the suit land on so and so, he was dispossessed on so and so, that is over.
my lord,
That is the finding which have been received.
my lord, one thing, my lord, if this is executed today, then my path will also go with this, my lord, because it is their admission, there is a path.
We will
Except the path, my lord, can you
know
see,
what to do in the execution.
without taking the path, my lord, they may execute the
Yes.
degree.
Okay, only the judges to write. such
Plaintiff
things.
purchase, he has excluded the path land from defendant number 2 to 7. Now kindly see the schedule, my lord. Whether they have mentioned in the southern boundary is the path, my lord. Kindly see.
I'm not going into all these things. Matter is over. Hello.
My lord, kindly one thing, my lord.
No case.
My lord, kindly see the schedule, my lord. One thing, my lord. Oh, one schedule. Page 80.
Schedule of what?
Schedule of the playing.
Where is it?
Page 80.
Yes.
Northern boundary land of Liaquat Ali. But in the northern side, there is a path, my lord. It is from this paragraph 24 itself, it is reflect that there was a path. My land is the northern to the
In crossing and PW3 alone substantiated that the document PW in the one and one of the vendors on the crossing that on Iman he executed the sale deed where he has given the northern boundary. Where he has given northern boundary is the house of Liaquat Ali. He hasn't included the land of the aforesaid path within the scheduled land of the particular. He has excluded the path land of the defendant numbers 2 and from the schedule of the purchased land, and he has submitted document relating to allotment of IAR.
So this part, in this schedule, they have included this part also.
So then you have to challenge the sale deed. Nothing doing. You have to challenge the sale deed.
That has, that already challenged, madam. That
very
has
well.
already challenged.
No, but.
Now
this doesn't-
question is on the basis of this, if
Oh.
they are, they.
Or Mr. SK, no, Mr. Ghosh, these are trying to matters to be finished up immediately. Urge Mr. SK Ghosh, the learned counsel appearing. And Ms. So-and-so who appears on behalf of the respondent. On number one. 227 or 115, which one? The present proceeding is been put to challenge in the present proceeding, which is initiated by invoking the revisional jurisdiction of the court under section 115 of the Code of Civil Procedure 1908, or short the code. The order dated, the judgment and order decree dated 18th of February 2020, in title suit number 102 of 2014 have been put to challenge. It is relevant to take note of that title suit number 102 of 2014 is a proceeding, is a suit, is a suit filed under section 6 of the Specific Relief Act 1963. Taking for declaration of possession of the plaintiff over the scheduled land and for recovery of possession thereof in favor of the plaintiff against the principal defendants and for other reliefs. The question arises as to whether this court should exercise is required to exercise its revisional jurisdiction in the present facts of the case. It is seen that the respondent number one herein had filed a suit being title suit number
102 of 24, 2014.
102 of 2014. In the said suit, the case of the plaintiff, of the respondent number one, who is the plaintiff, is that the performer defendant number 20 and 21 by the registered deed of sale dated
31/8/2014.
bearing number,
No.
by the registered deed of sale bearing deed number 2775 dated 16/8/2014. Sold, transferred the land described in the schedule to the plaintiff in favor of the petitioner. This land, entire land.
Entire land. Mention entire land.
No. Transferred 7 kotha 8 shataks of land as more specifically described in the plain, scheduled to the plain, to the plaintiff and delivered possession to him on the date of execution of the deed of registered deed of sale. On 31/8/2014, the principal defendants, along with others, in absence of the plaintiff entered into the purchased land of the plaintiff and damaged the boundary fencing constructed by the plaintiff with CI sheets, and also completely damaged the 3 numbers of Kacha house and took possession of a house constructed by the performer defendant number 20 under the scheme of Indira Awas Yojana, bearing holding number 82, and a Kacha house with CIC roof bearing holding number 30, and dispossessed the plaintiff by assaulting his mother and the performer defendant number 20. On the basis of the said, the plaintiff immediately upon coming to learn filed an FIR before the lodged an FIR before the Hailakandi police station, which was registered and numbered as Hailakandi PS case number 491/14 under section 120B /147 /148 /427 325 326 307 308 of the Indian Penal Code. Subsequent thereto, on 6/9/2014, the suit was filed seeking a decree for recovery of possession of the scheduled properties in favor of the plaintiff by evicting the principal defendants and their men and agents, etc., and or anyone claiming to or under them by removal and dismantling of all obstructions and hindrances, and for temporary injunction and for permanent injunction against the principal defendants, restraining them from changing the nature and feature of the scheduled land in any manner. The summons upon being pursuant to the filing of the suit. Next, the pursuant to the filing of the suit, the defendants appeared and submitted the written statement. I had filed separate written statements. The performer defendant number 20 and 21 also filed a written statement supporting the defendant numbers. The defendants filed separate written statements. Defendants, but 1 and 8 to 19 in 1 and 8 to 19 filed a written statement. Denying the case of the plaintiff. Wherein it was stated that the performer defendant number 20 and 21 never had possession over the suit land. And the said performer defendant numbers 20 and 21 had created a deed bearing deed number 2775 dated 16/8/2014 by giving a false and imaginary boundary, including the land under the possession of the defendant number 1 and his brothers. The defendant number 2 to 7 also filed a written statement wherein denied the case of the plaintiff. It was stated that the defendant, that the said defendants were in possession of the suit land and the deed of sale bearing deed number 2775 dated 16/8/2014 contained a fictitious boundary in the northern side and in place of the answering defendant's park, they had given the land of Liaquat Ali in the northern boundary. The performer defendant number 20 and 21 filed a written statement supporting the case of the plaintiff. On the basis of the pleadings, as many as 7 issues were framed, page 32%, which are reproduced here in under. Next, on behalf of the plaintiff, 4 witnesses were examined. And on behalf of the defendant, 5 witnesses were examined. Both the plaintiff and the defendant adduced documentary evidence. The learned trial court, after detailed discussion of the evidence on record, came to a categorical finding that the plaintiff had proved his possession of the suit land prior to 31/8/2014. It was further observed by the learned trial court on the basis of the evidence on record, on the basis of the evidence that the principal defendants have dispossessed the plaintiff on 31/8/2014. It was the learned trial court further came to a categorical also opined that from the evidence on record, the defendants could show little to prove that they were in possession of the suit land prior to the dispossession on 31/8/2014. Accordingly, the learned trial court decreed the suit thereby declaring that the plaintiff was entitled to recover the possession of the suit land by evicting the principal defendants and their men and agents, etc., or anyone claiming through or under them by removing and dismantling all obstructions. The prayer for permanent injunction, however, was not granted. It is under such circumstances that present proceedings have been filed under section 115 of the code. Before further analyzing the legality and validity of the order. Judgment and decree dated 18th of February 2020 finds it relevant to analyze the scope of the revisional jurisdiction of this court under section 115 of the code. In this regard, this court finds it relevant to refer to the judgment of the Supreme Court in the case of Hindustan Petroleum. What is the name?
Petroleum purpose.
Hindustan Petroleum. The Constitution and judgment. Hindustan Petroleum Corporation which is and so, and the paragraph so and so is quoted here in below. From a perusal of the above quoted paragraph, exposition of law, it would be seen that the scope of jurisdiction under Article 227 of the Article 115 of the Code of Civil Procedure is limited to recently at a landlord tenancy etc. In the backdrop of the above exposition of law, let this court now take up the judgment and decree, the judgment so passed by the learned trial court. From a perusal of the impugned judgment, it will be seen that the learned trial court in detail have taken into account the evidence of both the parties. And have come to an opinion that the plaintiff could prove that he was handed over the possession of the suit land on 16/8/2014, and further could prove that on 31/8/2014, the plaintiff was dispossessed. The learned trial court further, after taking into account the evidence of the defendant, came to a categorical opinion that the defendant failed to show that they were in possession of the suit land prior to 31/8/2014. It was the categorical observation of the learned trial court that the defendant accepts stating that they were in possession of the suit land and they have not dispossessed the plaintiff. They had nothing to offer. On the basis thereof, the learned trial court had come to a finding that the plaintiff was in possession of the suit land on 16/8/2014, and he was dispossessed on 31/8/2014 without due process. The finding of facts so arrived at does not appear to be perverse. This court further takes note of that the jurisdiction so exercised by the learned trial court cannot be said to be a jurisdiction. This court further finds it relevant to observe that from a perusal of the impugned judgment and decree, it cannot be said that the learned trial court had exercised the jurisdiction not vested in it by law, or that the learned trial court had failed to exercise the jurisdiction vested on it by law. This court further is of the opinion that the learned trial court did not commit any illegality or material irregularity in exercising its jurisdiction. Under such circumstances, the question of exercising the revisional jurisdiction in the instant proceedings does not arise, for which the instant petition stands dismissed with cost quantified at rupees. How much? How much do you want? 15,000. 10,000. You have been there for 5 years.
31 rule 97.
Hmm?
My petition under order 31 rule 97 to 100 was rejected by the learned trial court.
So why are you here?
After order at page 33.
Well, you have to file an appeal against that. No case. What to do? Dismiss. Two options. Either withdraw to file an appeal, or I dismiss it on some. Which one? Either.
Let me obtain instruction.
No instructions. Instruction is not there. This is too long a process. Which one? Either of it. If I go into the merits, the case is to be dismissed. Because you are claiming through your husband. Your husband was the defendant in the suit. He filed an appeal during his lifetime. He filed a second appeal during his lifetime.
Filed by the plaintiff. Second appeal was filed by the plaintiff.
But your husband was there.
Sir.
So when the decree was passed in the second appeal, it was against your husband. So you are claiming under him. So you don't have a case. That is one, for which I can dismiss on merits. In view of Order 21, Rule 102, no case, finished. Or the second is, when an order is passed under Order 21, Rule 97 to 99 or 101, it is construed to be a decree under Order 21, Rule 103. Unless such an appeal lies against this. So therefore, you having approached under 227, this petition cannot be entertained, thereby granting you leave to file an appeal there against. Which one do you want?
To file an appeal.
That is one. I heard Mr. So-and-so, the learned counsel, appearing on behalf of the petitioner. The present proceedings have been by the instant petition. The supervisory jurisdiction of this court under Article 2 to 7 of the Constitution have been invoked, challenging the order dated 15/5/2024, passed in Mizze case number 96/2024, arising out of title execution case number 10/2016, whereby an application filed under Order 21, Rule 97, 99, and 101 of the Code of Civil Procedure 1908 was rejected. It is well settled that proceedings that an order so passed under Order 21, Rule 101 is an order coming within the ambit of is a decree in terms with Order 21, Rule 103 of the Code. Consequently, an appeal lies there against under Section 96 of the Code, read with Order 41, Rule 1 of the Code of Civil Procedure. It is well settled that when the Code of Civil Procedure provides a remedy against provides a remedy, the supervisory jurisdiction under Article 2 to 7 of the Constitution cannot be invoked. Considering the above, this court is not inclined to invoke its supervisory jurisdiction against the order dated 15/5/2024, passed in Mizze case number 96/2024, arising out of title execution case number 10/2016. Accordingly, the instant petition stands dismissed. Be that as it may, before parting with the record, this court observes that the dismissal of the instant petition shall not, however, preclude the petitioner herein to prefer an appeal under section 96 read with order 41 of the code. The period. In filing such appeal, the period from
Page 36.
two seven 2024 till date be excluded while computing the period of limitation. The interim orders passed on 3/7 2024, by which the further proceedings of title execution case number 10 of 2016 pending before the court of the learned civil judge senior division bracket Hailakandi was stayed, is vacated. Full stop. The learned executing court shall proceed with the execution of title execution case number 10 of 2016 in accordance with law. Full stop. The registry shall bring this order to the attention of the learned trial court by forfeit.
My lord,
The LCR which is being received, which was called for by this court, be forthwith returned to the learned executing court by the registry.
made.
What are you challenging?
Your Honor, this is an order which rejects my application for re-examination. We are in a suit, and in the suit there was a 39(1) and 2 that was filed. The title suit was regarding to a property. 39(1) and 2 is filed. Injunctions are passed against D1 and D2. I mean, for defendant number 1 in the suit. And the injunction is that you will allow ingress and egress to the plaintiffs. Now, there's a allegation that injunction order has been violated. A 39 2A application comes to be filed. Evidence is taking place in the in that application. So in that, my witness is examined, and then he's cross-examined. I mean,
Where is the impugn order?
Your Honor will find it right in preceding the page number 1. Preceding page number 1. It's after the list of dates.
So you have not enclosed it as a part of the order?
No, it's enclosed. That is where it was.
No, that is a different thing.
It's in the
Our
index.
learning council under 137 event for re-examination of DW1. Report on perusal of the petition filed by the have found that OP wants to re-examine himself on the ground of clarity. The other side has raised payment reason. They have clarified to what doubts in this court. It is in what proceeding?
This is in the 39.
What are you doing with an injunction proceedings and making it like a trial?
They are there's a cross-examination taking place to see whether I have violated the injunction orders or not. That is actually the large sum and substance of it. Now, in that, since I've been called, I'm the witness there, and I'm the defendant. So my
So
affidavit
it is in order 39 rule 2A proceeding.
Yeah.
So you want to re-examine.
that I don't want.
They want. So what is the problem?
Their petition may kindly be seen, madam, by which they have been dated to re-examine their petition, who has already been considered to have been discharged.
Where is it?
Residence, my lord.
Where is it?
Your Honor, may find it at
Page, my lord, start from
92.
90.
Huh?
92.
Page 90. So 1 page application.
And relevant portion is page number 93, my lord, paragraph 2 and 3. Paragraph 2 and 3.
When did they file this application?
My lord, 2/8/23, my lord.
After the cross.
The next date itself. What is wrong?
My lord,
You
there
should
is
have
no,
been allowed.
my lord, there is no any mention that what clarification they face, my lord.
Mr. Alam.
My lord, by way of filing this application, they-
Mr. Alam, let me answer. A re-examination is a right.
Okay.
The moment he asks for re-examination, the court has to give him immediately thereupon. Now the question is, if the re-examination is given, if he brings in new facts, he will be entitled to cross-examine. That's the law.
That's right.
That must be clarified, my lord, on what point, what discrepancy they intend to clarify.
They will
That-
come up.
That has not been mentioned in this application, my lord.
No, let them come up. You will get your chance.
Like there's a
Because it's an order 39, if it is just an order 39, 1 and 2 proceedings, I would have dismissed this petition. But if it is a 2A, it will have penal consequences, so let him come up. Whatever may be, well, you will have a right of cross-examination, matter is, because the right of re-examination is inherent, therefore you see order 18 rule 4.2. Evidence, cross-examination and re-examination. Re-examination can be governed, and I find it when I was practicing also in the trial court as well as otherwise also. The court thinks that the re-examination you need to file an application. No, you can verbally ask the court immediately. Normally, it should have been asked on that day itself. You cannot at a later stage find out that yeah, okay, we have some loopholes. I want to fill it up. That cannot be permitted.
That has been done, my lord. By virtue of this
because it's-
application, that is not for my lord. By virtue of this application, that has been sought for to fill up the required, my lord.
That also you don't know. Because it doesn't
Take,
include.
take, my lord.
Huh?
What discrepancies we have?
Yeah, let him say you will have a right to cross-examine. You have come late, so cost of 25,000. 25,000 cost.
The take was immediately after the next day, the matter.
No, Mr. Das, the
I
question,
follow what's
no,
coming.
Mr. Das, the moment the cross-examination happened, you are to re-examine then and request the court. This is the law.
But because it was happening before the commissioner, I filed the application.
It happened before the commissioner. No cost. But Mr. Didas, Rupert Das, the learned counsel appearing on behalf of the petitioner, and the NLM who appears on behalf of the respondents. Where is that order?
Your Honor, the impugned order?
Yes.
Order was filed right in front, after the list of dates, Your Honor. That's what.
No, you have not made it an annexure.
No, we did.
Well, what is your annexure?
We were told, Your Honor, that it's been put as, if Your Honor may have my list of, my index, it's been
It's
put as
the
item. number
council. Are you not, when you are impugning an order, are you not making it a part of your
No,
petition?
I am. I had in fact my
So,
first draft.
no, show me in which
It's not been-
petition you have enclosed. Petition, you will be enclosing that order, which annexure.
I have not enclosed it as an annexure, Your Honor.
Then we dismiss on that ground.
Your Honor, may kindly.
No,
Your Honor, may
on
kindly
that
consider
ground
this is
we
the
dismiss.
instructions of the registry.
This is not the function. Who has filed the writ petition?
I have filed.
No, then it is your duty that it has to be made a part of the order, part of the petition.
I have made it a part of the.
Where is it?
Your Honor,
Where have you enclosed that order?
Your Honor, may I have the, right after the list of dates.
No, I'm
Your
not
Honor, may I-
concerned with list of dates. Where is it a part of the order?
Your Honor,
Petition.
it's part of my petition.
No, it is not.
Your-
It is not there.
Your Honor may consider.
No,
When, Your Honor may consider,
No,
when I filed this application, it was an annexure.
no.
I was
nothing.
informed that the certified copy has to be put prior. So that is why I.
Mr. Das, I know that. Every certified copy has to be put prior, but where is it mentioned in your petition?
Where is it mentioned in my petition?
Yes,
Okay, sorry, I apologize.
that is the specific question. How will he have a copy of that order?
The whole set.
No, it cannot be.
It's not been annexed.
That document will be always outside. It is not a part of this petition.
Because. If I look.
Furthermore, your lordship cannot take a lot of other things. Page number 2 petition, may can be seen. Dictionary suggest take care, my lord.
Huh?
Dictionary suggest take care.
Ah.
Now, your lordship, can you turn to page number 27, my lord.
Hmm.
Affidavit in support of this petition has been filed by somebody else.
So that's his son, because Mr.
Huh?
Sanjeev Sekar is going to,
What?
it's been filed by his son,
Page
through a power of
27,
attorney.
page 27, my lord.
And I put the son's power of attorney as well.
Petition has been filed by himself. Affidavit has been shown by his attorney. Without any explanation in the entire petition, my lord.
I put it in the affidavit. I made that clarification in the affidavit. And I put the, power of attorney as well.
So the attorney says out here that the petitioner wants a re-examination.
Yes.
How will he say? How will he say? Tell me. How will he say? Can he have personal knowledge on that?
So the examination will be of the petitioner himself.
No. Who can request?
You know, the petitioner will always, the witness will have to request.
The witness will come up before the court.
Absolutely correct. Sir.
Now here the witness happens to be the petitioner.
Absolutely correct.
Now the petitioner comes up and files an application before the, but here who is before this court? It is through an attorney. Can the attorney give that evidence,
So the,
that requirement?
Your Honor may direct that it has to be the petitioner who will come forward to give the,
No.
he's in some medical difficulty. That is why we have actually taken this course. That is a genuine issue, Your Honor. He is under some medical treatment.
And this. You are delaying the order 39 into a.
I've not asked for a stay. Your
procedure.
Honor. I've not asked for a stay.
Going on. Finish.
I don't, still, the land tried to be on the transfer file. That's why put it back in.
But even though I've paid for it here, I didn't press for it for exactly this reason. My intention is not to delay, Your Honor.
The intention is for delay.
Not at all, Your Honor.
Evidences have been completed. Now matter is to be hard by the land trial to pass this order. Evidences have been completed, my lord.
You have not enclosed that order. You should dismiss your petition on this ground.
Your Honor, may kindly give me some permission to rectify this and put it on order by way of an additional affidavit.
No.
Because this is what was informed to me.
Who? How many years of practice you are having in the principal seat? You have a lot of practice. Are you going to, have you filed ever a writ petition?
I have, Your Honor.
Then in that writ petition, are you going to put the impugn order outside?
Your Honor,
Is it not required? You are moving under 227, exercising
No,
the
I think-
supervisory
I take it.
jurisdiction, and you are not bringing it within the fold of the petition. Then
Your Honor, may kindly give me some time to file it by way of an additional affidavit.
what?
The impugned order, certified copy of the impugned order. It is, I did have filed it, but it is, Your Honor is correct. It is not mentioned that it has been filed because the page numbering is not there. Very honestly, I was confused by this process myself, Your Honor. I have to confess.
Were you confused?
I was,
You confused.
it had,
Because of you being confused,
No.
I'll put it in my order. That is, you are confused, I will allow this petition. As because of the fault of the council, the client should not.
I think that is fair.
And it should be put in, that order should put it in bold letters.
I apologize, Your Honor.
There is not apology and a cost of 10,000 upon you. So that you remember next time, don't make this type of mistake on you. Legal services. Mr. So-and-so, the learned counsel appearing on behalf of the petition, and Mr. N. Alam, the learned counsel appearing on behalf of the respondents. At the outset, Mr. Drupad Das, the learned counsel appearing on behalf of the petition, submits that he was confused and was not aware.
Honorable say erroneous impression.
No, absolutely. Your word was confused, didn't you? It is recorded. You can see it. Was confused and was not aware that the impugned order is required to be made a part of the petition. He was under the impression that the impugned order is just required to be tagged along with the, is required to be filed with the petition and not made an annexure to the petition. This court, taking into account that it is a mistake committed by the council and on account of a well-settled principle of law that a party should not suffer on account of a fault of a council. This court proceeds with the disposal of the instant proceedings without taking cognizance of such a mistake. Next. The supervisory jurisdiction of the court have been invoked under Article 2 to 7 of the Constitution, challenging the order dated 18/7/2024, passed by the learned court of the court of the civil judge, senior division number 1, Kamrup Metro at Guwahati, whereby an application filed under section 137 and 138 of the Indian Evidence Act 1872, read with section 151 of the Code of Civil Procedure 1908 for re-examination of the DW1 was rejected. From the materials and report, it is seen that the respondents herein have filed an application under Order 39 Rule 2A, alleging violation of an injunction order. Have you enclosed that or not?
I have enclosed.
Alleging violation of an order dated 28/2/2018 by the respondents, by the petitioner. Passed in NISJ case number 100/2018, arising out of title suit number 50/2017. In the said proceeding, the respondents have adduced evidence. The plaintiff, the petitioner herein, who was the defendant, who was the opposite party in the said proceedings, have also adduced evidence. The cross-examination of the petitioner, was done before the
That is a serious contribution.
was done at the residence of the petitioner. After the learned trial court had issued a commission, the said cross-examination was carried out on 28/7/2023. At that point of time, the petitioner herein did not have an opportunity to seek re-examination, as the commissioner did not have the power to permit re-examination on his or her own. It is under such circumstances, on 2/8/2023, the application was filed under section 137 and 138 of the Indian Evidence Act 1872, read with section 151 of the Code of Civil Procedure, seeking re-examination of the plaintiff witness of the petitioner. Upon filing of the said application, the respondents herein had filed a written objection. The learned trial court, by the impugned order dated 18/7/2024, rejected the said application. On the ground that the application so filed by the petitioner seeking re-examination did not specify what doubts and discrepancies were required to be clarified through re-examination, and as such rejected the same. It is under such circumstances the present proceedings have been initiated. I've heard the learned counsels appearing on behalf of the parties and have given an anxious consideration to the materials on record. The right to re-examine a witness of the party calling the witness is inherent. It is settled position of law that if there is a requirement to seek certain clarification as regards any doubts and discrepancies, the learned court, before whom the cross-examination is being conducted, is required to give an opportunity to the person, to the party calling the witness, to re-examine his or her witness. It is also well settled that in the process of re-examination, if any new additional materials are being brought on record, any additional materials are stated, the opposite party, the party who had earlier cross-examined, would have a right to re-cross-examine the said witness. That being a settled principle of law, that being a settled principle of law, this court finds it relevant to take note of that the petitioner herein was cross-examined on commission at his residence. And the commissioner could not have permitted the petitioner to be re-examined unless there was specific authorization given by the learned trial court. Consequently, the petitioner was therefore required to file an application which the petitioner had filed on 2/8/2023. The reason for rejection by the impugned order, in the opinion of this court, was not proper, taking into account that the moment that the right to re-examine being an inherent right, the learned trial court could not have rejected the said exercise of the right. Consequently, this court interferes with the order dated 18/7/2024 and allows the petition number 5263/2023 filed by the petitioner seeking re-examination of the petitioner. This court takes. When is the next date? No idea, na? 24th of?
April.
It has been brought to the attention of the court that the next date is fixed in the suit as well as in the proceedings under Order 39, Rule 2A on 24th of April 2025. The parties herein who are duly represented shall draw the attention of the learned trial court of this order so passed, and the learned trial court shall pass appropriate orders according.
Deeply applied.
Nine. Mr. D does no more mistakes next time. And this is the third mistake. Earlier also remember another matter. I remember. I have my black book out there. Can count on.
Pleasure.
Learn the CPC properly. Yes, what is this? Oh, Mr. Sahu.
The Ghana trial court has rejected the prayer for injunction, temporary injunction. And the appellate court has granted status quo. Whereas, my lord, if we go through the plaint, only grievance of the plaintiff is that he has not been paid the consideration amount.
Then
Look, the fact is that the both the parties have entered into an agreement in the year 2020 in respect of the civil and land. The tag number of the land was covered by 97. Earlier parties were in impression that the entire land
how much you were entitled?
according to him
42 lakhs.
42 lakhs, total it was 42 lakhs.
Huh?
Total 42 lakhs.
Out of which you have paid 11.
8 earlier at the time of agreement it was paid.
Then
And when he was in hospital, my lord, he was paid amount.
there was a sale deed done.
Yes, my lord. Because the earlier agreement was in respect of 1 cut of 5 lakhs. It was covered by DAG number 97 of 150, PP number 150. Later on, it was found that only 16 lesser falls under DAG number 97. Remaining 9 lesser falls under without 99, not DAG number 99. Therefore, he obtained permission only to the extent of 16 lesser. So, to that 16 lesser, he got the registered sale deed. And for remaining 9 lesser, he got the agreement for selling out. This was our. But he is now alleging that I have violated the term of the agreement made in the year 2020. And another allegation is that when he was in the hospital, we went and forcefully took his signature. That is not materialism, because in the plaint itself we have said that we are claiming that I have given him certain amount to his sister for his treatment. He is denying that he did not get it. So material issue is not in my humble submission that he has not got the entire amount And we have got 16 letters by way of registration deed and 9 letters we have got below an agreement, sale of agreement. Whereas below the agreement was for 1 kata and 5 years.
So you are in possession.
I am in possession. Below.
Now what is the injunction passed?
Injunction passed for status quo.
Status.
So you are there. What is your problem?
Now I am constructing a house there. And that was almost complete, Milord.
Oh, 20%. Is
Yeah.
this the case? 20%. Is this the case? Oh, that is another one. Okay. And nowadays keep on getting similar man. Yes. You are constructing house.
House.
House done.
That was almost complete, Milord.
So you want to further construct.
That finishing touch, Milord. And Milord, even if I will allowed to do that, if he gets degree, then you will get a building from me. Milord.
Are this an undertaking? Where is that order I have passed in over? Yes. Mr. Mr. Samnur Ali, na? I show it to him. See, this is the order which I'll propose to pass, provided you file that. See the conditions. So what you are required to do is also given. Take your instructions from your client.
Milord.
But the thing is, it is I who normally pass this type of order. Others don't. So, I won't be sitting from first. So if you can file your affidavit by Wednesday, we can take it up on Friday and pass for 7 hours. When do you want it?
After. After. Right.
Let them file by Wednesday, let it come.
So you get a similar order to that effect. So, yes, you see, if you have part only construction is being done, 20% or some finishing you have to do, go ahead, you do it. Because otherwise there is a problem out there. If he loses the case tomorrow, you are also at a loss because you are not being able to enjoy the property. On the other hand, if he wins the case, you give him what he needs, including the building. Okay.
Otherwise, his degree will affect me.
It's very difficult to execute. Degree would be very difficult to execute. Let it give an undertaking in the line of the church. Let it give an
No, that is what. You have to give an undertaking that you will not require a separate decree for the house you are making out. Because this I am doing it in terms of there is one judgment. It's a very beautiful judgment on possession. There it says there was a case out there that whether during the pendency of a construction, any construction done, is it required to have a separate decree if you don't take the leave of the court? Then it says that no, the court can do so because the possession is whatever may be. That is a beautiful judgment on order. That is the main case is on order 21 with 35. But this is being given. It's a beautiful judgment.
The pair is legal itself to recovery of person by uprooting the structure already made.
But we are also praying for cancellation of the same because we have alleged that it's a fraudulent.
Pair itself is there.
No, they may not like, they may use it.
You know?
They may like to use the structure. What is your problem? Otherwise, you remain happy like this. Fight out on litigation for 10 years. When do you want it? Let's point the time.
Friday.
Other councils do it.
Right, everything.
The Sahud, the learned counsel submits that he obtained certain instructions in the matter and requests the matter to be listed on Friday. The date to the Mr. I. Well, it feels on behalf of those. Give a copy of that to him also, huh? Hey, to, no, he copy to Rakhi. That day, one matter was coming out there of Mr. P.K. Roy. I could not pass that order.
I'll give it yours.
His name is Sloan.
Name on the list.
Sloan. The person order categorically.
Person order to reflect his name. Name is not.
His name.
It's the listing of matter. Take it. Why the name is not used? The order is clear. Wait, after some time.
Item 10. There's an appeal by the insurance company. And the award passed by MSC February lawsuit. Awarded at €225. Our ground of appeal is lawsuit. The loss of income assessed by the Honorable MSC Tribunal lawsuit. Lawsuit may come, first of all, lawsuit may come to page number 18 of the judgment lawsuit. There is annexure 1. Lawsuit. Para 20. Page number 18, para 20 lawsuit. In the middle portion of lawsuit, got it? It says that Exhibit 139 reveals that claimant Abdul Aziz Sarkar was admitted in the aforesaid hospital on 14 to 2017 and he was discharged from the hospital on 16 to. That means lordship, he was admitted only for 2 days as per his discharge certificate, lordship. Now lordship may come to page number 19, para 22. Here lordship, the Honorable Tribunal has assumed that he could not do his work for at least 3 months. Hence, the claimant is entitled to get rupees 6,000 as notional income per month into 3 months. That is 18,000 lordship. Lordship now may peruse annexure 2. That is a cross examination of the claimant lordship. That is page number 24. Page number 24, the middle portion lordship. The claimant is admitted. In the middle portion, he stated that I do not remember the days when I was admitted in the hospital. I have not submitted any document that was that I was under continuous treatment for 2 months. I have not submitted any exhibit, so and so, so and so. So no income proof was submitted by the claimant. He was only admitted for 2 days. And his loss of income has been given for 3 months. 18,000 lordship has been awarded. That is our main lordship plea of this appeal.
Only
It must-
18,000.
Only, so lordship, otherwise it's a settleable case, not much amount. Lordship, we want to settle this case also. Lordship it may allows us to direct this case to be placed before a local other.
Mr. Counsel. He's given 3 months.
3 months.
Not given any proof for that, but the court has arrived at some discretion of it. Now, otherwise, all other amounts is, that means you are entitled, liable to pay 2,61,000. 2 lakhs,
2,77,000.
2 lakhs, 59,000.
77,000. Total amount.
You are otherwise admitting 2,59,000.
Lordship,
What makes it sense? of having it 18,000. Then at the end of the day, if I admit it, you will be paying more interest. Don't you think so?
What happens, Lordship, if the authority, sanctions a case for appeal, Lordship, but we have to answer in audit, Lordship, there is an audit. So we have to answer it. If it.
No, don't worry on that. Therefore, my case is I'll dismiss your appeal. Dismiss your appeal. Pay that amount. Otherwise, at the end of the day, you will be paying more interest.
I understand.
So I'll dismiss your appeal now.
Lordship may issue right now, issue a notice, Lordship, in the next.
If I issue a notice, I will stay subject to 2,59,000.
I'm not asking for the stay, right? I'm not.
No, I will say this is the condition of which you are admitting.
Lordship.
See, I will then invoke Order 41, Rule 1(3). CPC? CPC?
Lordship.
Where is the CPC? Give it to him. Hassan, you have CPC? Anybody has the CPC?
I'll get in my.
Give it to him. Order 41, Rule 1(3). Order 41, Rule 1, bracket 3. Yes, read it.
Yes, sir.
The council, can it take such a long time to find a
Lordship.
provision? With the CPC, the big book, you are not finding it.
Lordship.
Huh?
Must be filed with a memorandum signed by the.
Not for this.
Lordship, at this, I pray, Lordship, at this stage.
Read that Order 41, Rule 1(3). You don't know where to see in the CPC. Give it to me. You don't know how to look at the CPC also.
Okay. There was one, 39, 30, 2013.
Mr. Hassan, just find it.
39.
Where is Order 41, Rule 1? Yes.
39, 40.
What does he say?
I don't know. That is two. No,
Take it up on the house.
this is the order for you. Yes.
Give the book, give the book.
Yes, let's go.
Yes, what is it read?
Where the appeal is against the decree of for payment of money, the appellant shall within such time as the appellate court may allow, deposit the amount disputed in the appeal or furnish such security in respect of thereof as the court will keep it.
Only as regards the disputed amount security, for which you give a bank guarantee of 18,000. And remaining amount you are to deposit with interest within 4 weeks. This is the condition for admission of the appeal. As we are not disputing the other. Don't require stay. So better off I dismiss the appeal. I hope. Heard Mr. So-and-so, the learned counsel appearing on behalf of the appellant. Full stop. The instant appeal filed under section 173 of the Motor Vehicles Act 1988 challenging the judgment and award dated 2/1/2025, passed in MSC case number 15/2020, bracket I, by the learned member MACT Dhubri, hereinafter referred to as the learned tribunal, whereby an amount of rupees 2,77,000 have been awarded as the compensation, along with interest at the rate of 7% from the date of filing of the claim proceedings till realization. In addition to that, the learned tribunal had also directed the appellant insurance company to make the payment within a period of 30 days by depositing it in a specific account number of the tribunal, as mentioned in paragraph number 25 of the impugned judgment and award. The sole ground on which the sole ground of objection taken to the impugned judgment and award is that the learned tribunal had awarded an amount of rupees 18,000 on the ground of loss of income for 3 months without there being any evidence to the effect that the claimant was not in a position to the sole ground of objection taken is that the learned tribunal had awarded an amount of rupees 18,000 on the head of loss of income for a period of 3 months. For 3 months, taking the income of the claimant notionally at rupees 6,000 per month. The counsel appearing on behalf of the appellant submitted that the claimant did not bring on record any evidence to the effect that the claimant was not in a position to undertake any work for the period of 3 months, and as such, the impugned judgment and award is required to be interfered with. In that regard, the learned counsel, for appearing on behalf of the appellant, has drew the attention of this court to the cross-examination of the claimant witness, who had stated that he had not submitted any document that he was in continuous treatment for 2 months. This court, in taking into account the said ground of objection, this court takes up this appeal for disposal at the stage of Order 41, Rule 11 of the Code. From a perusal of the materials on record, it will be seen that on 13/2/2023, the claimant, while proceeding as a pillion rider of a motorcycle bearing registration number AS-17G1523 towards Halakura Bazaar from his home, and on the way, when the aforesaid motorcycle reached near Halakura Cinema Hall on NH 31 at around 5 p.m., one Savaria SAVARI vehicle bearing registration number AS01AA/3982, driven in high speed and in a reckless manner, dashed the motorcycle of the claimant, resulting in injury to the claimant. The claimant further stated in his claim petition that he was taken initially to the Mission Hospital, Kuch Bihar, from where he was shifted to Dispur Polyclinic, Guwahati, where he undertook treatment as indoor patient from 14 to 2017 to 16 to 2017, and again from 9/3/2017 to 10/3/2017. It is the case of the claimant that on account of the accident, he had sustained multiple pelvic bone fracture along with uterial injury and hematoma around the symphysis public and vertical fracture at the left side of the sacrum with involvement of left-sided sacral foramina, dislocation of right shoulder joint besides other injuries due to the said accident. The claimant also claimed that he had incurred an expenditure of rupees 2,75,000 on account of medical treatment and that he, being a carpenter, used to get rupees 15,000, used to earn rupees 15,000 per month, which he could not earn on account of the accident. The record, it is further seen from the impugned judgment itself that notices were issued and only the appellant insurance company appeared and contested the suit by filing the written statement. The learned trial court, on the basis of the written statement, had framed 4 issues which are reproduced hereinunder. On behalf of the plaintiff, a claimant, 2 witnesses were adduced. The appellant insurance company, however, did not adduce any evidence. In respect to the issue number 1, the learned tribunal, by the impugned judgment and award dated 2/1/2025, awarded an amount of rupees 2,77,000 along with interest at the rate of 7% from the date of the claim petition. It is relevant to take note of that while deciding the said claim petition, the learned tribunal decided the issue number 1, holding inter alia that the accident took place due to rash and negligent driving of the vehicle number AS01AA3982 and AS17G1523 at the accident took place on account of the rash and negligent driving on the part of the driver of the sub-area vehicle bearing registration number AS01AA3982 and the claimant sustained injuries as a result of the aforesaid accident. In respect to the issue number 2, the learned tribunal came to an opine that the vehicle bearing registration number, the offending vehicle bearing registration number AS01AA/3982 was duly insured with the appellant insurance company. As regards the issue number 3 and 4, the learned tribunal, on the basis of the evidence on record, came to an opinion that though the claimant had claimed an amount of rupees 2,75,000 on account of medical expenses, but could not prove the said amount. On the basis of the evidence, that is the medical bills, the learned tribunal came to an opinion that an amount of rupees 1 lakh
Marcus. I voted for.
and came to an opinion that the tribunal, that the claimant would be only entitled to an amount of rupees 1,49,000. Inasmuch as the claimant had submitted medical bills amount vouching to rupees 1,70,647. And the ambulance, and out of which the ambulance fare was rupees 21,800. On the question of injury, on the head of pain and suffering, the learned tribunal had awarded an amount of rupees 1 lakh. In addition to that, the learned tribunal had awarded an amount of rupees 10,000 on the head of transportation charges. The learned tribunal further taking into account the evidence on report, more particularly the discharge certificate of the dispute polyclinic and nursing home exhibited as exhibit 3 to 6 came to our opinion that the petitioner, that the claimant would only be entitled to an amount of rupees 18,000 on the head of income, loss of income for a period of 3 months, taking the income of the claimant notionally at rupees 6,000 per month. On the basis thereof, the learned tribunal had arrived at a total amount, had adjudged an amount of rupees 2,77,000. This court, having perused the impugned judgment and taking into account the ground of objections so taken, is of the opinion that no case has been made out for interference in exercise of the appellate jurisdiction. Accordingly, the appeal stands dismissed with cost.
25,000 because it may be allowed to.
Stands dismissed. The appellant insurance company is directed to deposit the amount as directed by the learned tribunal, along with interest. The amount of rupees 2,77,000, along with interest at the rate of 7% per annum from the date of filing of the claim petition, within 6 weeks from the date of the instant order. This court further directs that upon deposit of the said amount before the learned tribunal and an order being produced from the learned tribunal before the registry of this court, the statutory deposit of rupees 25,000 so deposited by the appellant insurance company at the time of filing of the instant appeal be refunded by the registry upon an application filed by the respondent by the appellant insurance company before the registry.
August.
There shall be no order. Yes,
I got
are they genuine?
the report has been provided to us. Pass certificate is verified, my lord, and farm telling with the record.
I think you can have them. So on the basis of this, we pass that order. Heard Mr. A. Hassan, the learned counsel appearing on behalf of the petitioner. Mr.
Meteor on behalf of Mr. TC.
Is he around the vicinity of 100 yards of the High Court? Mr. T.C. Sutia appears, the standing counsel of the Assam What is that?
Assam State School
State School Education Board. Appears on behalf and Miss S. Sharma appears on behalf of the Guwahati High Court. Mr. C. Bulwa appears on behalf of the Accountant General. This court, by an order dated 19/3/2025, requested Mr. T.C. Sutia, the learned standing counsel of the Assam State School Education Board, to obtain instructions as to whether, as regards the veracity of Annexure 1 and Annexure 2 to the writ petition, which are the admit card and the pass certificate issued by SEBA. Today, Mr. D.K. Roy, the learned counsel who represents the Assam State School Education Board, has placed before this court an instruction issued by the Secretary, Assam State School Education Board, wherein it has been categorically mentioned that the photocopy, admit card and the pass certificate bearing roll number K-068, number 0506 of HSLC, 1983, found that the age as 16 years, 8 months, 00 days as on 1/3/1983. Taking into account the said document is kept on record and marked with the letter X. In the backdrop of the above, let this court take up the instant petition for disposal. The petitioner herein claimed that he appeared, the petitioner herein was temporarily appointed by an order dated 8/10/1986 by the then District and Session Judge Lakhimpur, North Lakhimpur, as a lower division assistant LDA in the office of the Subdivisional Judicial Magistrate SDJM, Dhemaji, attached to the additional public prosecutor, Dhemaji. The petitioner joined on 29/12/1986 as LDA. Subsequently, the petitioner, by an order dated 5/8/1992, was confirmed as LDA, issued by the Chief Judicial Magistrate, Dhemaji. After rendering a service, after rendering a length of continuous service, the petitioner was promoted as the upper division assistant by an order dated 21/2006, issued by the CGM Dhemaji, and posted as a bench assistant to the court of the additional CGM Dhemaji. The petitioner joined his post as bench assistant on 21/2006, and presently the petitioner is working as the supervisory assistant UDA in the office of the Chief Judicial Magistrate, Dhemaji, Assam. It is the specific case of the petitioner that at the time of joining as an LDA, the petitioner submitted before the authority concerned both the admit card and the HSLC pass certificate issued by SEBA. Secondary Education Board of Assam.
Board of Secondary Education Assam.
Okay, Board of Secondary Education. SEBA. Sorry. In order to record the actual date of birth of the petitioner in the service book, Because it is the further case of the petitioner that as on that in terms with the admit card as well as the pass certificate issued by the SEBA, the petitioner age was recorded as 16 years, 8 months, 0 days as on 1st of March 1983. However, the office of the Chief Judicial Magistrate wrongly recorded the date of birth of the petitioner in the service book as 5/3/1965, which ought to have been 1/7/1966. The petitioner had submitted a representation on 6/1/2025 before the CGM Dhemaji for correction of his wrong recording of the date of birth. The said representation was rejected by an order dated 30/1/2025. It is under such circumstances the present writ petition was filed. It is relevant to take note of that when the writ petition was moved before this court by an order dated 3/3/2025 issued notice and further directed the standing counsel appearing on behalf of the Guwahati High Court to file a short affidavit as to whether the admit card as well as the pass certificate issued in the year 1983 by the Board of Secondary Education, Assam, SEBA, were the documents which were duly submitted by the petitioner at the time of appointment of the petitioner, and further also produced the service book of the petitioner on the next date. The next date was fixed by the order dated 3/3/2025 on 18/3/2025. On account of the business of the court did not permit, on account that the business of the, on account of the business of the court did not permit the instant matter to be taken up on 18/3/2025, and therefore the matter was directed to be listed on 19/3/2025 at 2 p.m. On 18/3/2025, no affidavit was filed as directed by the order dated 3/3/2025. Under such circumstances, this court sought the appearance of the Chief Judicial Magistrate at 2 p.m. through video conferencing mode to know the status on the basis of which so that appropriate instructions could be so that the basis on which the petitioner's name, date of birth was inserted in the service book could be ascertained. The Chief Judicial Magistrate Demaji appeared through video conferencing mode and submitted that the appointment of the petitioner was made by the then district and session judge, not Lakhimpur, as at that point of time, the court at Dhemaji was a subdivisional court. See further, the learned the chief judicial magistrate further placed the scanned copy of the service book. Upon perusal of the said service book, it appeared that the same was prepared as far back as on 27/8/1986. And in the said service book, the date of birth of the petitioner was mentioned as 5/3/1965. This court duly inquired as to on what basis the said date of birth was inserted. However, the Chief Judicial Magistrate Demaji could not provide an answer on what basis the said date of birth was entered. So, accordingly, this court fixed the matter on 19/3/2025 at 2 p.m. for further hearing of the matter. So, taking into account that the authority who had the authority who made who had who was in charge of preparing the service book of the petitioner, of inserting the entries in the service book of the petitioner, was not aware as regards how the date of birth of the petitioner was inserted as 5/3/1965 in the service book. This court for the ends of justice requested Mr. T.C. Sutia, the learned standing counsel for the Assam State School Education Board, to verify as to whether the admit card as well as the pass certificate enclosed as Annexure 1 and 2 to the writ petition were genuine, inasmuch as the date of birth have been duly mentioned in the said two documents. It is under such circumstances, Mr. D.K. Roy has produced the document as already and kept on record and as already observed, and have been kept on record and marked with the letter X. First, I've heard the learned counsels appearing on behalf of the parties and given my anxious consideration. First, oh no, itu Y berarti X no Y. The service book of the petitioner. From a perusal of the scanned copy of the service book of the petitioner, it is apparent that the same was apparent. It is apparent from a perusal thereof that the same was that the entries was inserted on 27/8/1986. Inserted first on 27/8/1986 by the then subdivisional judicial magistrate Dhemaji. In the column number 5, it was mentioned that the date of birth to be 5/3/1965. The authority, however, did not have any document on the basis of which the said date of birth was mentioned. This court is aware of the fact that the petitioner herein ought to have agitated this aspect of the matter when the gradation lists were prepared, wherein his date of birth was mentioned as 5/3/1965. But the petitioner, however, for best reasons, did not do so. Be it as it may, if the date of birth was wrongly inserted in the service book, be it as it may, the date of birth, the entry in the date of birth in the service book is required to be entered into on the basis of certain documents. The petitioner herein, at the time of his appointment, had passed his HSLC exam. The genuineness of the documents which are kept on record, that is Annexure 1 and Annexure 2, have been duly verified by the Assam State School Education Board, as would appear from the document kept on record and marked with the letter Y. From the said document as kept on record with the and marked with the letter Y, read along with the admit card and the birth certificate of the petitioner, it is therefore apparent that the date of the birth of the petitioner, that the petitioners was 16 years, 8 months, 0 days as on 1/3/1983. Consequently, the petitioner's date of birth ought to have been recorded in the service book as 1/7/1966. On account of an erroneous insertion of the date of birth, the petitioner cannot be deprived of his due right to continue in the post if his date of birth was 1/7/1966. Cannot be deprived of his right to continue in the post which he is presently working. In that view of the matter, this court directs the Chief Judicial Magistrate, Dhemaji, to correct the date of birth of the petitioner in the service book as 1/7/1966. And in that view of the matter, the instant writ petition stands disposed of with the following observations and directions. Number 1, the Chief Judicial Magistrate Dhemaji is directed to correct the service book on the basis of the admit card, on the basis of the date of birth mentioned in the admit card, as well as the birth certificate issued by the Board of Secondary Education, Assam, wherein it is being mentioned that the petitioner is 16 years, 8 months, 0 days as on 1/3/1983. Number 2, on the basis of the said correction, the Chief Judicial Magistrate shall issue appropriate communications to whom? To the Accountant General, as well as to the Accountant General will do, or whom? No, I think it has to be given to also the Judicial Department. You will only come for the pension, but the pension also it has to be given to you and as well as to the judicial department of the government of Assam. Yep. Upon making such correction, the upon making such correction in the service book, due information be provided to the judicial department of the government of Assam, the Guwahati High Court in the administrative side, as well as to the office of the Accountant General. Accountant General, so that the said authorities can do the needful as regards do the needful. Any more? Anything more you want?
So far as PF account is concerned, the office of the accountant, and they have to correct the date of birth in the portal.
I
Otherwise,
said with the do the needful.
a specific direction may be given to the accountant. And
Did you ask for? Did you ask for? Eh? Do it. Episode number 3. Before parting with the report, this court finds it relevant. Take note of the submission of Mr. A. Hassan to the effect that also further specific directions are be required to be issued to the Accountant General, Office of the Accountant General, that in the portal,
GPF portal.
in the GPF portal, the correct date of birth should be now inserted. First, Mr. Sibul submits that upon receipt of the information from the Chief Judicial Magistrate as directed by this court, the Office of the Accountant General shall do the need. Okay.
Okay.
Month of March finishes in 20 days.
11.
Yes, Mr. Rava, why you are filing this appeal?
This is, yes,
Oh.
this, claim case, and we have come here for enhancement of the quantum of the order.
You are challenging?
We have
Asking
come
for
here
enhancement.
Enhancement,
Why?
because the spend order, the amount of commission was inadequate and also unfair.
Huh?
Amount awarded was very much inadequate and unfair.
Why?
Because the larger child tribunal adopted with the wrong approach of assessment of the compensation.
What is the wrong approach?
First, there is a specific statement and consistent evidence also that our income was monthly 10,000. Whereas the child tribunal took a notional amount, 9,000, that too, no legal value and no rationale at all.
So you are giving 4,609.
Yes.
Why? Married person having, no, you are given how much?
Lordship is the spend in paragraph 25 will
Not going to be awarded to the consortium in loss of consent, city. So the calculation is 9,000 plus future prospect, 40% of the total income. It is 3,000 in money equals to 13,000. Since the deceased was married person having 3 dependents, 2:3. So 109 equals to 9,000. Third, this is an appeal filed under section 173 of the Motor Vehicles Act 1973, 88, challenging the judgment and award dated 11/11/2024 passed in MSC case number 8/2019 by the bracket D, by the additional district judge MSC Tribunal bracket of Viswanath, whereby an amount of rupees 10,36,928 was awarded along with interest at the rate of 9% per annum, was awarded as the just and fair compensation. The learned counsel appearing on behalf of the appellant had submitted that the monthly income which have been recorded by the learned trial court, by the learned tribunal, was not based on evidence. The amount was inadequate, which taking into account that, taking into account the above, this court admits that it's the appeal call for the records, issues notice, call for the records. The appellant is directed to take steps upon the respondents by registered and usual.
Well,
What it is,
the enhancement of the sum of,
you want more money?
yes, my lord.
Why?
My lord, the medical expenses incurred, my lord, I have submitted the medical expenditure of more than 11 lakhs, my lord.
What happened to you?
But it was fracture of tibia and fibula, my lord. Fibula and tibia. Still, the petition, the appellant is under treatment, my lord.
Still under treatment.
Yes.
An appeal under section 173 of the Motor Vehicles Act, challenging the judgment and award dated 1/7/2024, passed in MSC case number 145/2018 bracket I by the learned member Motor Accidents Claims Tribunal, Dhubri, whereby an amount of rupees 4,89,000 was awarded as the compensation along with interest at the rate of 7% per annum. The learned counsel appearing on behalf of the appellant had submitted that the learned tribunal failed to take into consideration the evidence on record, more particularly the expenses so incurred towards medical expenses, towards the medical, and more particularly the medical expenses so incurred, which was to the tune of rupees 11 lakhs. Taking into account the above, appeal is admitted by Giggle. Huh?
13.
An appeal by the claimant, my lord. Basically on two counts, my lord.
Huh?
Basically on two counts, my lord.
Yes.
And my lord, learned tribunal erroneously held that the victim was an gratuitous passenger in the vehicle, my lord.
Huh?
Gratuitous passenger, my lord. It
Oh.
was a truck, my lord. He was working as the handyman and some cleaner, my lord.
Huh.
That finding, my lord, although that claimant specific case was that he was the cleaner and the handyman of the vehicle, and it was not opposed by the owner by filing the WS. He has filed the WS, he has not denied the fact. Planet Tribunal held that he was the gratuitous passenger in the truck.
What does the insurance company say?
That one point, another point, his income was assessed at 6,000 rupees lesser.
What the evidence did you give?
Yes, my lord.
So the appeal was dismissed.
No, appeal was not dismissed. It was held that the insurance company is not liable to pay.
Who is liable to pay?
It was that owner come driver. Paragraph, my lord. Actually, see the paragraph,
Or because of gratuitous passenger?
my lord.
And you are the owner.
I am the claimant.
So you are agreed by what?
I am agreed by two counts, my lord, that income has been assessed wrongly, my lord. It was assessed as 6,000, my lord. And the other point is that the finding of the tribunal that he is a gratuitous passenger is illegal. Right? This is a clear, my lord, lordship will find
But
in defense of
at
the
the end of
claimant.
the day,
My lord.
you are concerned with the money.
Yes.
The money has a color when it is paid by insurance and by the owner.
Owner.
They have a
That's
different color.
It's correct, but the finding is
No,
very.
we
Finding
have
the-
currency notes having green, orange and blue.
That is
But
correct.
our question is whether for insurance company, it's a different color.
After filing of the WS, the
So
owner did
your
not turn.
question is mainly on, not on beneficiaries. Beneficiaries will get, the owner
My
will
lord.
come. Your question is on the quantum.
Well, quantum.
Let us limit it to the quantum.
Fine.
Because the moment you are bringing the beneficiaries, you are fighting on behalf of the owner. Why should I?
Difficulty is that after filing up the WS, the owner did not turn up.
It is normally the owner does.
My lord.
So if
And
they
being
are
the
not, but
beneficial legislation, I
the
cannot-
direction is against the owner and rightly so. If it is so, they cannot be a pay and recover as per recently this is held, but although I don't agree with them, but it's a different thing. We'll decide on one day, but I am not here for that. I fix some matters on 28th.
This is my appeal of the ethics. My lord.
Can appeal against so and so one day judgment and amount we get. By an amount of. Who are your appellants? In which case?
My lord, MSC case number 65 of present, the murder.
MAC case number, judgment and awarding insofar as MAC case number 65 of the 2017, whereby an amount of rupees 3 lakhs was awarded.
No, my lord.
How much?
It was page 29, your lordship will find it.
Page? How much amount has been awarded?
Paragraph 29, your lordship. 9 lakhs 77,200. Page 35. In
Right.
respect of this petition, this appeal.
Amount of rupees 9,77,200 was awarded as the just and fair compensation, along with interest at the rate of 7% per annum. The date of filing of the claim petition. Till paid in the date of payment. The council appearing on behalf of the appellant submitted that the amount of rupees 6,000 taken as the monthly income was erroneous and not, and have been wrongly done in as much as income of the deceased was much more as would be apparent from a perusal of the record evidence. Taking into account the above, the appeal is sorry, on the steps. Okay. 14.
Lordship, this appeal is filed against dismissal of the claim petition, Lordship.
What, you want a dismissal?
The claim petition was dismissed, Lordship.
Huh?
The claim petition was dismissed.
Why? Why was the claim petition dismissed? Where is your claim petition? Where? Where is the order?
The order is annexure 5,
In
page
view of the
49.
right that this claim is not maintainable. Why is it not maintainable? The insurance in a cause because the car which was the deceased was driving was registered in his name. Immediately in the present case, the vehicle being driven by the deceased fell into the pond, resulting in his death. The claimants are claiming compensation. They registered the personal car. The claim is not maintained. Motor vehicle technique. So it was your car,
Yes, Lordship.
and in that car you had the accident, and you died. You don't die,
This is right.
the deceased died. It was the deceased own car. So does the insurance policy provide for any other amount?
Yes, insurance, as the deceased was having a package policy, lordship, and on the package policy, the claim petition is maintainable. It covers both the third party liability and the damage to the insured vehicle itself, lordship.
The insured vehicle is different. Insured vehicle is different. The vehicle is a different aspect which cannot be compared with the person. For the person, you have to have a separate cover. An insurance policy, you have to have a separate cover, don't you?
We have got a own damage claim of rupees 15 lakhs.
Own damage, how much it was?
15 lakhs.
And that you did not get.
No, we have not received that amount.
Show me the insurance policy.
That we have not annexed the lordship.
What is this? You should have been. What is your main thing?
It was exhibited before a tribunal, lordship.
And
So if the matter is
you have enclosed out here the entire evidence of everybody, isn't it? But you have not enclosed the most vital document.
not received,
then-
that
Bring on record that affidavit. Whatever. Additional affidavit. It's this matter again on when? 4th of April. 4th of April 2025, which is the council hearing on behalf of the appellant shall file an additional insurance policy on the basis of which the claim seeks the compensation. Didn't it come within the ambit of the consumer protection?
we
If the
we did not
insurance
approve the
policy was clear, didn't it come within the ambit of the consumer protection? How will you go for the motor vehicle? Possible.
as the-
Anyways, find it out. Anyways, I'm not there. So the appeal, although it was mentioned as SAO, but it was an RSA. And this RSA was withdrawn. So the judgment of the learned trial court remains. So it has attained finality. So if it has attained finality, what was the judgment passed by the learned trial court? Let us look at it. It was there. It was upheld by the concurrent finding. It was dismissed. It was dismissed. So it being dismissed is being filed by whom? My lord. You are there, my lord, performer. Rudrabir Kaki. He had 9 sons. Rudrabir Karki. Who is he? Sarki. Who is he? In the present case, who is he? In the present case, he is the respondent. Respondent. There he was promoted. He died, my lord. So they have asked for right title and interest with consequential relief for confirmation of possession. Possession in Schedule B land and delivery of khas possession, khas and vacant possession by victim the defendant. heard Mr. Official Netherlands Council Assistant President appearing on behalf of them. The section 100 of the Code of challenging the judgment and defeat passed by the learned citizen seniority at page 2. Title appeal number 2. Thereby, the appeal judgment and defeat passed by the learned number. The instant appeal is admitted on the following substantial question of law. Whether the learned first appellate court was justified in coming to a finding that the principles of res judicata shall not the ground that on the ground that the second appeal means the judgment
99
the second appeal means the judgment dated (24/9/1998) passed in title appeal number 32/1995. Was not decided, was withdrawn. Getting in a
I meant
for the records.
any additional ground, right? Any additional ground?
Not really, this will be. Because that is the main issue. They filed a suit earlier, that suit got dismissed. And I'll just reframe it properly. I think we need to include the question of law, it should be whether the doctrine of merger would not apply. Anyways, I'll do it. All for the record, steps be here. You are there?
I am prepared for respond number 1.
Hey, you're paying well.
Client came to know about this case. He instructed you to appear on the respond number 1.
But that is wrong. That is a wrong finding. See, the moment the appeal is withdrawn, the appeal passing the appellate also by the appellate court attains finality. So there is no question.
One more thing is the
Punya is the judgment.
paper stay, madam. Paper stay. The different number 1, the appellant hearing, was himself the plaintiff in the earlier suit, who jointly filed the suit praying for right to interest. And the plain itself shows that madam, nothing has been inherited from late Atal Singh, their ancestor. Rudrabir Singh was one of the sons of late Atal Singh. And 2 sons, that is Tularam Charki and Siraram Charki, got the land from the government, and settlement was done in their favor. From there, well, the hierarchy was maintained. And as by virtue of the inheritance, the present plaintiffs are the owner and the possessor of the suit land. And now they are claiming that when we filed a suit for right title interest, they came up in the WS with a standard barred by red judicata. But the question is whether he himself was the party there, plaintiff, who sought for right title interest. Their suit was dismissed along with us. So Rudrabir Charki.
So you filed the suit against him.
We filed the suit
The earlier suit, my lord. Sobi Maya, Akbar Ali, Sanchar Ali.
Who is Budhamaya Sarki?
Yes.
Who is he? The defendant here. Is he appellant here?
My lord,
Budhamaya Sarki?
No, Budumaya Sarki is not.
I don't have the memo of appeal.
She's not there.
Sabi Maya, Charki, Akbar Ali, Sanchar Ali, Samar Ali, Talar Ali, Tarafat Ali, Marfar Ali, Abdul Hakim Ali, Ajmal Ali, and Arfar Ali, Kalu, Rudrabit.
Here it is there. Na? Appellant number 5. Appellant number 5. Appellant number 6. Appellant number 4. They all come from Budhamaya Sarki. They are all inherited. I think we're okay. Let us see when the year. But this, it is only on that issue. Investigated. If they make out the case, it's okay. We'll see the records out there because we may have to look at the citations. Because you see, appellant number 4, 5, there. I don't know the others because SAO, this SAO does not contain the claim. But the suit was filed one against one Budhamaya Sarki, claiming right title by you. Along with him, maybe one, the different thing. But claiming that he may not have a right. The appellant number 1, 2, 3 may not have a right, but 4, 5, 6 will have a right of res judicata. Because taking into account that the suit filed by you for right title in interest was dismissed.
But they filed a joint written statement in the current suit, came up with the plea that the suit is barred by res judicata, which has been nullified by the trial court. And the defendant also failed to prove their stand before the trial court with evidence. Could have been adduced by them.
But the finding of that there is no res judicata, we are not concerned with that effect. Therefore, I'm not going to do the thing. Here, the trial court, what has happened, the first appellate court comes to a finding that an appeal, the suit was dismissed. Thereupon, an appeal was filed, the appeal was dismissed. Second appeal was filed. Well, second appeal was withdrawn on the basis of some compromise, but nothing happened. But the order is, it is withdrawn. Once it is withdrawn, the judgment passed by the learned first appellate court has attained finality. It is a law. Now the first appellate court says that it has not attained finality. This goes against the judgment of the Supreme Court in Punya. So it is final. So it's absolutely final. Now the finality having been attached, this it happens to be a wrong foundation. Maybe a case of remand for them to be decided. The best thing which you are appearing out here only for defendant number 1.
And others could not sign because they are out of state.
Anyway, we'll be appearing for them also. Na? Anyway, we do one thing. As you are going to appear, should I say record that you will be appearing?
Yes, my lord.
Okay. Mr. S. Biswas, call for records. Good stuff. Taking into account that Mr. S. Biswas appears and represents the respondent numbers 1 to 6. 1 to 6, na?
1 to 6.
1 to 6. 6.
Only on 7 million notice will go.
1 to 6. Extra copies of the memo of appeal be served upon him within 2 days. First, the registry shall the registry is directed to call for the records and forthwith. First, liberty given to both the parties to file appropriate application for listing of the matter for hearing. Upon receipt of the records, liberty given to both the parties to file appropriate application for hearing of the appeal. Early hearing of the appeal. This is an application filed under Order 41, Rule 5 for stay of the judgment and decree dated 26/9/2024, passed by the learned court of the civil judge, senior division, Punitpur at Tejpur, entitled appeal number 29/8 of the 2018. This court had already admitted the accompanying appeal by formulating a substantial question of law. Taking into account that the decree which has been passed in the instant proceeding is an executable decree, and the petitioner would be, the applicants would, and it would cause irreparable substantial loss to the appellants if the decree is, judgment and decree is not stayed pending adjudication of the instant appeal. The judgment and decree dated 26/9/2024, passed by the learned civil judge so and so, entitled appeal number 28 of the 2018, shall remain stayed till the disposal of the accompanying appeal. I is bottom.
18.
Yes, what is this hospital business?
But here before the trial court, the certified copies of the transfer deed was exhibited, and the trial court as well as the first appellate court held that
Was my opinion bad or good against you? On the last date, was my opinion good or bad?
the lordship
No,
was-
no. Answer my specific question.
Because I could not.
No,
produce the-
Mr. Dhar, kindly come to the point. Was my opinion good or bad? If it is good, go ahead. Bad, from first, I'm not sitting. That is my question.
Well, on last occasion, I could not produce the transfer deed. In fact, that transfer deed was.
Oh, I remember your case now.
Yes.
Yes.
That transfer deed.
Why did these person file it? Your case is what my specific question to you was, why did this particular authority file it, whereas the property belonged to somebody else and you did
Yes.
not bring on record that transferred it?
Yes, that is exhibit 4. I got this exhibit 4. It is this properties was transferred by a trust to another trust. That was the case and that is why I could not answer that query.
The registered document?
Yes. And it was certified copy was produced and that was not accepted.
So exhibited.
It is the exhibit 4. Page 3, this deed of transfer from one trust to another trust.
Where is the property mentioned in the trust?
My lord. It's second last page.
Ah.
There are around 2,589 acres. total.
Where?
My lord, number 2 is the suit property. It's a part of schedule number 2 of schedule A.
page 17, the schedule
Patta number 118.
11853.
So this is being transferred to another.
No, man, yes, this was transferred to the plaintiff by the Baptist Mission, the trust, and this the plaintiff is also a trust. I have transferred these properties for the purpose of setting up an health institute, hospital, and that is the deed which is not considered by the trial court as well as the first appellate court. Certified copy was executed, and in fact, the trial court also held that official witnesses were called, but they have not appeared before the court. In the first appellate stage, one application was filed that was rejected, and this honorable court also observed page 77, my lord. That 41 will
You
27.
have submitted a photocopy.
No, my lord.
Huh?
Certified
Which
copy.
PW1 in his evidence stated that
that
the
wrong-
original
wrong-
owner of the
wrong-
suit
wrongly
property is
reported.
so-and-so and subsequently so-and-so transferred the suit patta in favor of the plaintiff by the exhibit here. PW1 deposed that the suit land pertains to periodic patta number 101 or Moza so-and-so and submitted exhibit 5, which is the copy of the Jamabandi in here. Now on perusal of exhibit 4 and 5, it is seen that both the documents are submitted in photocopies.
These are certified copies. my lord. Kindly see
Photocopies.
page,
Exhibit
page-
4 is the certified copy of the
yes,
registered there pertaining towards the trust and therefore the said deed is a private deed in nature. As per section so and so, it is the burden upon the party to prove the contents of the certified copy by using secondary evidence and yeah. So you have not done that.
my lord, that was done.
Where?
My lord,
How did you prove exhibit 4?
my lord, the official witnesses were called, page 48,
Ah,
but they have not appeared before the court.
So?
That, and the first appellate stage, an application under 41-127 was filed. That was rejected, and this honorable court also observed that
oh yes, I remember. I passed an order to that effect
Yes.
that you should be taken into consideration at the time of hearing.
Yeah, but-
And they did not consider this. This is a substantial question of
Yes.
law, isn't it?
my lord, in fact, I have.
So it's a
searched-
very short substantial question of law, not others. We are not going to look into others. It's a case of remand.
Fine.
Isn't it?
But court has to see, has to give a reasonable order and whether, why it has not accepted it, why it has not. accepted.
Well, that application has to be disposed at the, in the
At the time
judgment.
it's appealed.
That is the only substantial. You are the plaintiff.
I'm,
You have no urgency.
I'm not in position.
Huh?
I'm not in position of it.
You don't have any urgency. You have.
I have several others are also.
They admit it and put it in the records for all years to come. After 10 years, the matter will be disposed.
Lordship will dispose it.
Heard Mr. A. George of Learning Council appearing on behalf of the appellant. Is in file under section 100 of the Code of Civil Procedure 1908, whereby the judgment and decree dated 30/9/2024 passed in title appeal number 44/2010 by the learned court of the civil judge, senior division, Bench, that is the first appellate court, is been assailed. The instant appeal is admitted on the following substantial question of law. Whether the learned first appellate court was justified in dismissing the appeal filed by the appellant without considering the application under Order 41, Rule 27 of the code filed at the appellate stage for proving Exhibit 4 and Exhibit 5 course not necessary, necessary because there will be call for the records, plaintiff is directed to take steps upon the respondents by way of registered as well as trustee. In addition to that, the petitioner plaintiff is further given the liberty to take steps upon the respond by way of the state. The registry of this. Call for the records about the meeting. Call for the records equally. Taking into account the substantial question of law which have been formulated above, this court directs the registry to bring on record, to forfeit, procure the records of the learned first appellate court, that is appellate court pertaining to title appeal number 44/2010. The next date of the appeal is fixed on 28/5/2024-25. The records be placed before this court as directed above, be placed before this court on the next.
Applies.
Mr. Chaudhary, bad case, good case.
Perhaps Lordship would not like to take up the matter. Because the appellant's wife, my lord, is related to Lordship. I got to know only day before yesterday. She is the lord and the daughter of Krishna Kanta home of Dibrugarh. That is Dutiram Thomas granddaughter. Biplab.
Near the bench. We have it on 2nd of April. 2nd of April 2000.
So that's item 20 to 22.
What is this?
Your Lordship, service has not been completed against some of the respondents.
Huh?
Service has not been completed against some of the respondents.
What is this CRP business? Why you have filed a CRP?
CRP. Yes. Here we have filed a title suit. The petitioner has filed a title suit. And notice has been issued to all. Nobody appears. So the case proceed expertly. And after that,
Continue.
after judgment and decree passed in our favor, and that judgment and decree has been challenged by filing application for restoration by
In
the
order
three,
9 Rule 13.
by the three dependents.
Then
Then that has been dismissed. Then again, they filed title appeal, miscellaneous title appeal before the civil judge. And civil judge has allowed these three petitions. These three petitions against as many as there are defendant, as many as 15 persons. And
wrong.
now the three person has filed title appeal, miscellaneous title appeal,
and the judgment entity was in there. Satisfied? Against that order, I have filed this here.
No witness.
That's the way-
When you serve it, was there any no witness or not?
No, paper publication is there. Your Honor.
Not here. Trial court. No witness.
Not, in two cases, there is a paper publication.
Where?
Here are other.
No, not here. Trial court.
Yes, your lordship,
There was a paper publication.
paper publication.
And in this case, it was in this case, which is 188.
One,
That is
one
not a case of paper publication.
yes, there is no paper publication.
It is
But
a
in
case
other
of-
two cases, there is a paper.
It is a case of that hanging.
Yes.
Hanging the summons,
Yes.
isn't it?
Yes.
Then don't you think as per the civil rules and orders, more particularly 64 and 65, right? There is a requirement that there has to be two witnesses.
But so far, the same persons, they have not appeared, so there is a publication.
No, not here. That is no problem. Whether they appear or not, I am not concerned. You are there. He must be there for somebody. For whom?
I'm in 188, my lord, for the respondent number 4, 5, 6, 7, and 9.
So in this case, there is is being done by the Lotkajari.
No, not Lord, my lord, it is said, my lord, in 188, it says it was refused. My lord,
It is refused.
in 188, my lord, 5 attempts were made. But my lord, he could not, on 3 occasions, it says he refused. One occasion, house of the defendant not found. And my lord, on another occasion, it is reported that defendant was not found. Page 38, paragraph 8.
As to how did he affect service? By Lotkajari. By putting it, hanging in the wall,
But that is
by
not done.
pasting. Now, if you are doing it by pasting, it requires that you have to have two witnesses. Isn't it? The law, 64 and 65. Civil rules and order, not being done. What is wrong with this order then?
No,
The counsel, you are the plaintiff.
I'm the plaintiff.
So,
I'm the
under
plaintiff.
such circumstances, how
He
will,
refused to accept
how
three
will
times.
this
Your Lord.
delay out here will affect you?
He refused to accept the notice. It is equivalent. to
Understood, but
service.
if he has refused to accept the notice, the proper procedure is not only the serving officer, those two witnesses should come out there and say that these are the two witnesses who
Now-
have appeared and this is his evidence. Where is it? The witness that this was, the support is not there with any witness. They serve without a witness, matter over. Then you can very well manage. This is how, I think there is one judgment of 1993. You got it? Got it? No. I think all you are appearing, then we put it for admission. Yeah, you have done paper publication, no?
Yes,
All the three cases.
all the three cases.
Okay, well, let us put it for admission. Take out the judgment of 1993, Guwahati. Yeah. And the other two, paper publication.
Paper publication.
Why does the trial court hold it? Fellow, I would not today finish up these three. Otherwise, case for dismissal. Simple.
Interim.
Taking into account that the admission and the service have been affected by way of paper publication. This matter for admission or when? You are not in a hurry.
In the last part of April, anyway.
Why don't we do until let us admit these things and keep it on record? After 10 years, it may happen. We'll be also happy, isn't it? Isn't this decree stayed? Because it has been set aside, na?
Yes.
So he doesn't have a decree as of now.
Now interestingly, nobody who has filed, this 3% who has filed the appeal, miscellaneous appeal, they didn't appear in this case.
Understood everything, but the end of the day, you need to finish up these matters as soon as possible. Because once you finish up, then the suit will start. Anyways, taking into account the service is complete, this matter for admission on 19th of May 2025.
Interim order is there.
What interim order? There cannot be an interim order. You
No,
don't
there
have a
is, there
decree
is an
today.
interim order that has been continued till date.
No. What is the interim order? Tell me. Can there be an interim order?
No, the status quo we maintain.
Status quo for what? How can there be a status quo? You have to file an injunction application somewhere. As of now, you have to file an injunction trial court. You see, we are in a 227 or 115 jurisdiction. Where is the question of status quo we maintain here? He is the person
That
concerned.
order has already been passed by.
I am not
Senior-
going to enhance.
Senior
this type of
judges,
order.
your motion.
Sorry, man. If I
24.
don't say anything, then people will, you may say anything. But nowadays you will show it out there that the court did not extend it in the video. Yes. Yes. What is this? Tana has appeared on behalf of the external financial. The taking into account that the service is complete and the LCR is received, list the matter for hearing in its usual course, liberty given to both the parties to file application for early hearing.
But the date may be fixed.
You can't fix it. You file an application for early hearing. Your only matrimonial appeal is not only pending, there are many other matrimonial. So you have to give a reason.
Was directed to pay 10 lakhs rupees lordship to the present respondent.
You file it, I,
Master plan.
25 and 26.
what is this?
The two applications in these two items, item 2 and 26, are for amendment of the written statement, my lord.
Amendment of the,
Written statement.
you are the defendant.
I was the defendant, my lord.
Now you want to amend the written statement
Written
here.
because
Why?
after in last lecture, my lord, they have served a notice for demarcation of the fruitland. Fruitland is a part of land of 2,000, more than 2,000 acres land. There are more than 1,000 persons residing over the land. And my lord, the question is now some new persons have been brought in as boundary persons. But
You have filed your affidavit,
yes, we have objected.
reply you have filed,
Yes, objected.
the I,
Yes,
they have not been received by the section. When did you file it? The affidavit, Mr. MD Kadir says that the affidavit has been filed, however. the
I have also
court
filed reply.
received- Huh?
I have also filed my reply, my against the
With the eighth of, on the main case. Affidavit has been received by the section. No affidavit has been received. What affidavit? What is this order? Is it that he will file an affidavit in reply against the objection filed? So you have filed your reply.
Yes.
Mr. So the council appearing on behalf of the appellant submits that a reply affidavit has been filed. However, the said affidavit will not on record list the matter on
in the last part of April.
2nd of May 2025.
There is some urgency, my lord. Because my lord, the RSA is filed, my lord, only on the delay ground, my lord. The first appeal was filed after 3 years of the judgment of the trial court, my lord. And on that ground, the first appeal is dismissed, my lord, because after 3 years it is filed. So, my lord,
I have to look into this respect. And fix it any other date now.
the night paper is short.
Mr. Kade, I am holding this roster only till 28th of March. Thereafter to impose upon other, my colleague judges should not be. If it was, the matter came up in the month of first week of March, I would have fixed it immediately and pleased. It is 2nd of May.
And 28.
Date when met.
2nd of May. What is this?
May I please the last, my lord? The contempt was filed by the petitioner. The petitioner, every party, senior counsel is not being present before the honorable court, my lord. Now this,
So, you have
my-
filed your reply?
my lord,
You have filed your reply?
my filed a reply, my lord.
Contempt, and what is this CRP?
My lord, this contempt arises out of CRPM, my lord. May I take your lordship, my lord,
That's okay. The other side is not.
or not
represented.
present, my lord, that is why.
The counsel appearing on behalf of the petitioner is not present. Mr. So-and-so appears on behalf of the respondent who submits their affidavit have already been filed with the respondent. Taking into account the above, is this matter for on 7th of May 2025.
My seven, my lord, with your lordship. Eight, with all respect.
Not eight. It will be 9th of May
With all respect.
2025.
9th of May.
9th of May 2025. So it is observed that if the petitioner is not represented on the next day, this court has to proceed with the disposal of the instant proceeding.
29.
Much obliged.
What is this cross objection filed in an FAO?
That's it.
What is this cross objection?
That's it. That is not fact.
But not come. However, an objection dated demand filed by the respondent has been received in IA so and so. IA is there.
I is also there. Because along with lordship, what happened?
What is
both
this?
are not
Cross
filed.
objection has not been received.
Lordship.
You have filed it.
Yes, lordship.
Cross objection you have received.
Lordship.
Uh,
And there's an IA application also because the registry says that there's a delay. Initially, as per CPC lordship, there's no delay. Even then, registry says no, you have to file an application section 5. Under such circumstances, we have filed it as an abandoned portion, your lordship. So
What
there
is
not
this
fact,
FAO cross objection business?
lordship.
What is the FAO order actually?
FAO, lordship, injunction order.
Against an injunction
Against
order,
partly,
you have
injunction
filed a cross
partly
objection.
granted, partly refused. And
both
so
of
far,
you.
our part is concerned by that order, lordship, in spite of there having order, that as per direction of the Lane trial court, we have removed this seat from one gate. Even then, court has directed us to remove it. So for that purpose, we filed for it. Otherwise, not. So that is fact, this is not fact, Mr. Man.
Okay, Mr. Akif Bhuya submits that the cross objection has been filed. However, the same has not been taken. The registry shall bring on record the said cross objection. Is the appeal for orders for admission?
Lordship,
Admission on when? 7th April,
7th.
7th April 2025.
30. Land acquisition compensation was passed ex parte without hearing the petitioner. There is a stay order. Lordship may dispose of the matter, not setting aside the ex parte order.
Service complete.
Service complete.
Service being complete leaves the matter for admission when? On 4th of April.
Okay. Malad, the stay,
What is the reason you have filed in this matter? Why you have approached this court?
this land compensation order was passed
by the additional deputy district judge, without hearing the petition.
Who are you?
I'm the landowner, but there was a DAG number mistake in the DAG number, which was purchased in the year 2001. But instead of DAG number recorded DAG number 107, DAG number was recorded 111. So circle officer, I am in possession of the land. So at the time of acquisition, the acquisition proceeding, they have found me in the land. So the circle officers and all, they have given me notice. And they have, ultimately the matter was referred to the additional district judge for the purpose of completion. And the additional district judge, and that notice, if your lordship looks into.
Then thereafter,
And then the additional district judge has, without hearing me, have passed the order of compensation.
stating,
Passed the order of compensation, Malad, in favor of the original landowner. From whom, my lord, I bought them. It's on record.
so are you, if you are aggrieved by that, are you not required to come under 54 of the Land Acquisition Act?
Malad,
Why you are
earlier we
filing
filed
a-
writ petition? Because the land.
No, 54 of the, is it done under the old act or the new act? No. Acquisition proceedings started when?
Acquisition proceedings 2000, notice from the cycle officer, 16.
So acquisition proceedings started in 2016. So it will be an appeal against the new act. নতুন appeal তো নতুন এখন right to pay compensation. An LA appeal.
But because it is an ex parte order, we filed writ petition. Your lordship says, you file a petition under two
No,
twenty-seven.
right to pay. No, you can't come under 152.7. If it is an order by which the matter has been finally disposed of, the
Yeah.
compared reference case has been disposed of, you have to, if you agree, you have to file an
Reference
appeal.
case, Malad, when this is under section, that if your lordship looks into that paragraph, page 41, that is the order passed.
To file the appeal. This is done under what provision? Right, in Assam? This is done in Assam, I think it will be done under the Assam Acquisition and Requisition
I
Act.
think a national highway.
This is National Highway Act. So National Highway Act, this order is being passed under
This order is passed under, Malad,
3H5.
3H4.
3H4, okay, 3H4, 3H5, 3H4. This order is being passed. So against that, a National Highway Act can be.
That reference your lordship will get in the page 40.
Eight?
40. And copy was marked to me also.
Given the National Highway Act. So there is no appellate forum.
I did not find, Malad. But here in this case, Malad, I was not.
Who filed this application? You filed the application.
Originally, Malad, the notice came to us.
No,
From
who
the
filed the
circle
application?
officer,
No,
not
who
the-
filed the application under 3H4? 3H4.
By the ADC. ADC.
When ADC makes a reference when you object.
ADC has passed the order because he was unable to disburse them.
As to who should be entitled to. So the ADC had made the reference. Now what does he hold it?
That is at page 40. And copy marked to all persons, including the petitioner.
Reference is thus answered according to the extent of what the compensation is evaluated. be adjusted for the purpose of hearing in view of the above, the interested person, so and so, and others are entitled to receive the remaining compensation. Your name is?
Amrit Chandra Bora.
As far as the alleged claim of a compensation amount by
Three,
Amit Bora is
four.
concerned, having been seen the background of the facts, this court does not suppose that there is any right to equity, for he has by his acts, without any semblance of right, effectively prevented the heir from enjoying the.
Number 4.
Therefore, you are coming under 227.
Here we file under 226, but your lordship guided us to file it.
226 won't lie.
So what I was.
So
saying,
your notice was not issued to you.
Not only. I was not heard in them, therefore. Pay
And what about the service?
service is complete.
Who is appearing? None.
No, I think they are not.
Or 1 to 7.
Someone should be there in additional deputy commissioner.
Taking into account the office note dated 23/2025, the service is deemed to be complete against the respondent numbers, against the respondents. However, none has appeared. Taking into account that we list this matter for admission on 4th of April 2020. What is this IA business?
That was stay, my lord. Your lordship is granted stay till today.
The interim order passed in 6/12/2020. 371. Can continue in the next.
The interim will continue.
First,
31.
yes,
Alert the services are complete. Number 1 refused and 2 and 3 have taken custody services.
service complete.
1 has refused and 2 and 3 have accepted the notice.
Continue. There is no stay.
No stay. Lordship wishes it can be disposed of, my lord. It's a small matter. One amendment of claim where the defendant have not yet appeared. Summons have not been issued. Can be allowed and.
Defendant has not appeared.
That,
What is wrong with the
Ah.
court?
I don't know, my lord. My lord may come to
And why is he writing such a long order?
page 48, my lord. Order. The
Page 68.
My lord may read the operative part at page 79, my lord. 79, my lord.
Yes.
The order 6 rule 17 of
In the instant case, it appears that the case has been pending at the very nature. In fact, summons to the other side have not been issued as of now. Thus, it is clear that trial has not commenced. Again, a careful revision of the instant reason. When the suit was reserved for declaration, on the other hand, the petition depicts the plaintiff by way of amendment intends to ensure recovery of possession of certain land. By the proposal, it is seen the plaintiff intends to recoup. Yes.
That's failed. It was the
Which
court
court is this? Where is the petition?
amendment petition, Malak,
Hmm.
at page 48, man.
Steps have not been done.
We have filed an affidavit, my lord, with regard to service.
Okay. Taking into account the service having been affected, taking into account the affidavit so filed, comma, this court deems the service to be complete against the respondents, numbers 1, 2, and 3. First, list the matter for admission on 26th of March. Finish it off on that day. You are here?
Yes.
You are here normally, although you try. Show yourself to be a counsel from Jorhat.
32.
Replay.
But Mr. Sahewala, it is shocking. Why unnecessary spoiling judicial time in writing these type of books? Yes, 4 and 5.
Right, the owner and driver.
Strike out.
No, no, Malak, presence is required. It's a case where one of the initially investigation started and that,
Taking into account that the service upon the respondent number 4 and 5 is not complete, the appellant is directed to take fresh steps upon the respondent number 4 and 5 within 7 days by way of registered post. In addition to that, the appellant is also given the liberty to take effect service upon the respondent number 4 and 5 by way of dusty routed through the registry of this court and file an affidavit of service on or before the next. It's the matter again on 3/05/2021.
I am appealing for respondent 1 and 2, Lordship.
Very good, you are appearing.
They deposited 50% of the awarded amount. I have filed an application for release of the same.
Very
Let
good.
them attempt to state the following. 26.
No. Your file, you mention it.
33.
You do one thing, Mr. Talukdar, wait. Let me adjourn this matter. Okay, Mr. M. Talukdar, appearing on behalf of the respondent numbers 1, 2 and 2 submit that an application has been filed for release of 50% of the said amount, which is registered as I number
ISC 69925.
answer. Good stop. List this matter again on 28th of March 2025.
This matter.
What?
This matter is the daily matter. State one.
Where? 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 At Kohima. Don't worry, we'll take it at 4:15. No state consumer success statement. On 28/3/2025.
And we not 26.
28.
So we would like to file our.
Respondents, the appellants will be at liberty to file their reply by 26th of by on or before the next.
Obliged.
Yes, what is this?
Where appearing on respondent number 2, my lord. I'll be obliged, my lord, to get a copy of the petition, my lord, at our post.
What is the matter about?
What is the matter? The petitioner purchased land from Pokhamara Esplanade 9 and 10
File to the
and thereafter registered sale.
What are you challenging? Wait. What are you challenging?
Petitioner. Petitioner purchased land from Pokhamara Esplanade.
It's that, madam, what are you challenging here? Tell me.
Order dated 29/8/2024 and extra.
Page
170.
70.
Page 170.
What is that?
page 117. Impugned order
117.
dated 10/7/2024. Chapter 17.
10/7 Iman was Suratman, order 1 with 10. It's so and so to have purchased the land. Event number 1, so and so file written of the. What is the suit for?
Petitioner purchased land from proforma respondent number 9 and 10. Thereafter, proforma respondent suit was expertise. But thereafter, proforma respondent number application is filed and vacant expertise order. Therefore, their expertise is accepted and their written statement of accepted. But petitioner filed when petitioner came to know, he filed. a
Who is the
petition
plaintiff?
supplement of petition, but there.
Who is plaintiff? Suit. You have no objection?
But actually, I have received the
No,
document.
no, I'm not saying that. Do you have any objection as regards the impleading of, you want the impleadment?
Yes, he paid for impleadment.
That was
It was
rejected.
rejected on the ground that our cell deed is under challenge in another suit.
So what?
And
He should have been made a party. And what is your suit for?
my suit was for that the land was my predecessors of interest, and that land was inherited by 8 legal heirs. And I was claiming for 1/8 share,
So you are asking for partition.
partition of 1/8.
So he says that he has purchased. He has purchased that
Yes,
land.
her claim is that she purchased it, but she was not made part
In this suit.
in that suit.
In this suit.
That is her,
And it was rejected because of that.
because of that another suit is
So
pending.
you are the plaintiff. Who is objecting? Mrs. Doctor, you are objecting.
The paper, so I requested that they should speak.
For whom are you representing?
Respondent number 2.
Only respondent to file objection and on the behalf of.
So you are the defendant number 1.
Objection, my suit is. my
How is the
petition
defendant
rejected.
number 1 objecting to an impleadment petition? Let us not go into much into the fact, but how is it possible?
No, your lordship, petitioner number 1, not file any objection on
Yeah.
implementation.
Madam, that is why,
File,
Madam, that is why being shocked, I'm asking Mr. Doctor about.
yes, your lordship.
How a defendant is objecting that a person should not be made another co-defendant when the plaintiff is not objecting.
The scenario of all that, I'm not aware.
Okay, Mr. S. Dutta, assisted by so-and-so, appears on behalf of the respondent number 2. He submits that he has not received the copy. This court have perused the copy of the petition. This court have perused the content, the impugned order. From a perusal of the impugned order, it is seen that the plaintiff have not objected to the applications seeking impleadment in the suit. Rather, the defendant number 1, who is the respondent number 2 herein, had objected. Taking into account the above, the counsel for the petitioner is directed to serve an extra copy of the petition to Mr. So-and-so, appearing, assisting the Mr. S. Dr. the learned senior counsel appearing for the respondent number 2. List this matter again on 4th of April 2025. So taking into account the above, the service upon the others are dispensed with.
Much.
34. And the suit is not progressing. I will finish it up on 28th. Leave the matter on 28th for admission.
28.
Will you finish it up? These type of small matters,
I'm appearing for 1.
you're a plaintiff. You have no objection. What is this 34?
Your Honor, as per the last order dated.
No. What is your case for? Service is complete?
Your Honor, service is not completed. We had taken steps as per the last order via registered post with
What
AG.
is your case for? What are you challenging?
I'm aggrieved by an order dated 29/7/24.
Respondents
by
have
the
refused to
civil
accept the
justice.
use. You have taken a dusty service.
Yes.
They have refused.
Out of the 9 defendants, only respondent 8 and 9 have accepted it, rest all have refused. But the honorable court had directed us to take usual process and through a registered AD also. And respondent 1, 2, 6, 7 and 9 have filed their.
You are appealing for whom?
I am appearing from Lordship, respondent number 9.
Who is he?
In main suit, I am a performer defendant.
What about the others?
1, 6 and 7.
Are you appearing for the plaintiff? Is anybody appearing for the plaintiff? Who is appearing for the plaintiff? You are appearing for the plaintiff. Okay. If you are appearing for the plaintiff, then the service is complete. You want to file the wakalatnama of others, you file it. But how many plaintiffs were there? 9 plaintiffs. So you cannot be that, okay, I only appear for 6 and 3 are not there. This type of working does not work. He wants to acceptance of his written statement, nah? Depart from filing of the written statement. And his ground is taken that on the same day the petitioner had filed an application on the order 7 for rejection of the plaintiff as well as for keeping in abeyance. The trial court by the same order had kept the suit in abeyance till the disposal of area and had also debarred the filing of the written. That is his case, simple case. His written statement has to be taken on account. You can't debar it. You are appearing for everybody, for the plaintiff. Mr. So-and-so appears on behalf of the respondent, the respondent number 1 to 9, and you appear for the respondent number 10.
9.
1 to 8, and so appears for the respondent number. Taking into account above the service is complete, list this matter for admission on 28th of March 2025, puts the interim order passed earlier shall continue till then. We dispose it of on that date.
Right.
If I, Lordship, excuse me, earlier matter it is fixed on 28th, can it be on 1st April? I'll be away on.
Thank you.
No, Lordship, kindly, 3rd April.
Heard it. Your matter should have been allowed immediately, but I don't
Okay.
know whether
That-
thereafter, I don't know. Anyway, because you don't have an interim order, that is why I'm concerned. As per the, I go to 4th April. Huh?
Highly obliged.
Yes, Mr. Samaria, what are these?
Lordship, twofold prayer. First, Lordship, give some time to get instruction from the department. Lordship, otherwise, issue is very clear, my lord, that Lordship, only one thing is that, my lord, degree pass, my lord, without jurisdiction nullity, that principle attracts here, my lord.
But now it has the jurisdiction.
Exactly, my lord. That's why, my lord, it requires, otherwise, 2 ways, my lord. It has to be regularized in terms of this new notification 2024.
Regularized, no. You see, the fact remains. Earlier, the petition ought to have been sent by the reference, ought to have been made by the learned trial, by the
Right.
court, by that particular area to the Kamrup district metro. So what he did, he made it to the Kamrup rural. Rural did not have the jurisdiction then. But however, the rural wrongly or rightly registered it. It did not have the jurisdiction as it was not there, but subsequently the rural has been granted a
Yes,
registration.
yes, my lord.
Once the rural is being granted the registration, the rural has now the power to proceed
My lord,
with
normally
the.
what happened, my lord, suppose civil court, my lord, that problem we are facing. Suppose
Huh?
20 lakhs jurisdiction sometimes change, again the matter referred, again it will come to suppose the jurisdictional issue, my lord, in respect to civil court. 20 lakhs issue, my lord. Sometimes the high court.
No. These are reference proceedings.
Reference
is-
question, no, what I'm just setting example, my lord. What happened that because, my lord, once there is a jurisdiction come down, my lord, then definitely, my lord, that all matter referred from the high court. Again, it was changed, again it was referred, my lord. What I'm saying, my lord, in this case, can you sit for a moment, my lord, that 2024 is there. Now, suppose a order will pass this for that side, my lord.
The question that point of time where the cognizance was taken care of, my lord, the cognizance itself is supposed to be suffering from legal infirmities, my lord. Because that notification clearly says that jurisdiction not deserved by the.
Mr. Counsel, are you challenging the reference order? Not the proceeding.
No.
Are you challenging the reference order?
Exactly, my lord, because
No, you are not challenging the reference order.
for cognizance order I have challenged, my lord.
You cannot challenge the reference order under 115 or 227 because this court is not exercising 227 jurisdiction against the DC.
Quite right, but yes.
So you are not challenging the reference
No,
order.
absolutely, yes. It is
You
the
are
tribunal, my lord.
challenging the reference proceeding.
Yes, absolutely, my lord.
Now, as of now, the reference court has the jurisdiction.
Lordship, I have just searched, my lord, two judgments. my
Any act prior to it being got any jurisdiction may be not proper.
lord. 1954 judgment just now, my lord, I have searched, my lord, Supreme Court, where, my lord, the situation that suppose about the, my lord, lack of jurisdiction issue, my lord. That lack of jurisdiction, 1954 Supreme
But
Court judgment says.
Is it the case in 1954 wherein it says that subsequently, if that court gets the jurisdiction before
Exactly,
whom
but
the matter is pending,
that's his my
then
mind.
also you have to make it known
But-
as.
Well, that's why it hits my mind that suppose subsequently that has been, suppose given the jurisdiction. Then, my lord, when they, if it deserve the jurisdiction, the time starts there.
What is why, that is why I asked you, what is the stage of the proceedings?
My proceeding, my lord, that has been stayed, my lord, because last,
So, okay, nothing remains on that.
lordship, just pray one date, my lord, so that.
No
all
dates.
these issues, my
These
lord,
are not for dates. These are for written objection being filed.
my lord, yes.
Written
Objection has been filed
objection
by-
filed by the respondent number 3 against the instant reference proceeding pending before the honorable court. And there you have gone on the 64. Now the
My objection
jurisdiction
has been filed, my lord. There is no
the
any problem. my
claimant
lord. That matter is not to be heard
identified.
because we have filed the
Mr.
issue of 60.
You see what, the reference, where's the reference order?
My reference order, my lord, that contained in page, my lord, page 26, my lord, the notification which was issued, they have put state, my lord, it is otherwise also very interesting. My lord, page 13, my lord. Kindly see the in what manner, there is no any judicial order, there is no any administrative order. How the practice was going on there, page 13, just my lord, put the signature and it was,
Now, this is the acquisition of, from the date of publication of this notice. This is being done under the 64 Act.
64, my lord.
Then. So
Well-
they have made it to the collector.
Yes, my lord.
Now the collector says that it will give it to the district court.
Yes, my lord.
Then what is wrong with that?
My lord, thing that.
Why you are referring to the 2013 Act?
Because not 13, but it is their case, but the.
No, Mr. Counsel. Is your case? You are referring to the 2013 Act. The fact remains that this acquisition is being done under the Acquisition and Requisition Act. Now you see, Section 12 of the Act, it incorporates by legislation the Land Acquisition Act 1894, not the 2013 Act.
The reference which has been made by the party itself, they have met 2013, that's why, my lord, we have.
No. They will get the compensation in terms of the 13 Act.
Yes, ma'am.
You see,
Yes, equation, my lord, that is clear, my lord.
it will be, this court has the right jurisdiction.
Yes.
You get the point? I would have understood that if it was done under the 64, that is why our Assam government normally they don't do the 64. They give only the benefit of the 64 to
Yes.
everybody. So they are doing under the Requisition and Acquisition Act, and by 12, Section 12 of the Requisition and Acquisition Act categorically mandates that the provisions of the Land Acquisition Act will apply. Now, by legislation, by incorporation, they have only included the Land Acquisition Act.
Right.
So therefore, it will apply in terms of Section 18. So 18 will be to the collector, to the civil court. The civil court will be that court.
Yes, ma'am.
So therefore, that court has the jurisdiction in view of this proceeding. I would have understood what that it may not be. Because for that, you need to appoint them as a reference authority.
Yes, yes, 64. ma'am.
So what to do? Withdraw, dismiss, which one?
But only one instruction, my lord, because my government.
No
made a-
instruction business. You may have an instruction morning, you may tell me.
my lord,
I'll pass the order tomorrow.
because the officer which I have contacted is not able to understand the thing. Lordship, can it Friday, madam?
Show him what I have said. Okay? Show him what it is. Explain to him.
Lordship, Friday, my lord, no problem. Friday.
No Friday. I don't have time for Friday to sign up. This is an order which we.
Thursday, my lord.
No Thursday. Thursday lots of matters. Thursday is a very busy day. We'll have it
Only one day, my lord, because just to consult.
one day. Okay. Hey, Gute Gita. From 8 to 44. Tomorrow at 2. One day I'm giving.
Right.
But this is the point. I think, but tomorrow we dismiss with cost. Today
My lord, if
is
required, I
free
will withdraw.
withdrawal.
My post may not be because my lord, ultimately government is.
You have stayed it.
But advantage Assam is.
What
having
you
to
have-
pay.
Forget about that. But what you have done is you have stayed the proceedings, which is going to harm you.
Yes, sir.
You see, the problem which happened, any delay in the requisition.
My lord, interest.
I passed one judgment recently, a
I
very
have
important.
Otherwise case, my lord, otherwise case 2012, lordship has passed that interest 12%, 9% and 15%, my lord.
Which-
Acquisition case by 2024.
Oh,
Otherwise,
but
bus stand case, my lord.
Mizoram?
No, otherwise, Guwahati, otherwise bus stand case.
Oh,
it is
yes, yes.
59 years then, my lord. Lordship, from 2012, my lord, the
No,
interest.
there in Mizoram, I have passed an order of 2002 case with 34 interest from 15% from 2001. 5 crores.
Morning, my lord, if required, I will withdraw. There is no problem. Just
I think you withdraw because it will have a, because you see, therefore the problem is this act would not apply. They may file it. And the big problem is happening because the people are understanding
Yes,
that it is, we may file this way or there. But that is not the question out there. In fact, I delivered a very important judgment on land acquisition where I said the reference court has no business to decide on the maintainability of the reference. Maintainability of the reference can be only decided by the writ,
70.
either by the beneficiary or the person interest. It can be done by the year. Just for example, if there is a delay, just for example, if you see 64.
This is also suffering from delay, my lord.
No, in the case of 64, it says that it can be, has to be made within 6 weeks or 6 months. But 1 year is being given not to the court.
Subject to the setting.
No. To the collector.
To the collector, this
So therefore, the collector has the power to do that. Now, collector cannot exercise Section 5 of the Limitation Act.
Yes.
So if the collector cannot apply the Section 5, so therefore, any order being passed by them, holding that it is making a reference, it will be deemed that for the purpose of the reference court, it is final.
Right.
Maybe for the purpose of, you can challenge it before the writ court, but not there. So this is a very important thing because otherwise what is happening, this reference courts keeps on going as if it's a suit.
Yes, my lord, endless proceeding.
What is required is the moment reference is made, he is to issue notice.
Yes.
Once he notice, all persons should be asked to file their written statement. There is no claimant business.
Not-
And to decide what is the reference.
Yes.
You are aware, you should be helping out the courts and instead getting stay. Anyway, tomorrow at 2, we'll finish up.
Item 45.
What is wrong? Why you are not taking steps?
No, LCR received.
LCR has been-
LCR received. It will go for hearing.
Appearing?
Yes.
Oh, it is MFA?
MFE.
Actually good.
This order passed by the railway claims.
Oh, 45?
45.
Okay. I can know 45, okay. Service being complete and the LCR having been received, is the matter for hearing in the usual course, liberty given to
46 also said.
46 name. 47,
47.
yes, transfer, what are you doing?
Sir,
Who is going where?
we have taken steps. The transfer should be from Udalguri to Morigaon.
You are the husband.
Today I felt bubble up the malak. Take time for malak.
Why do you need?
Take time for.
It's a case of divorce.
Yes, sir.
Are you not in urgency for a divorce?
Today
No, tell me.
the malak.
If you want to file wakalatnama, this is nothing is going to change. Here, there is a reason why I have given the case that where petitioner is presently staying with her parents at Morigaon and does not have an independent source of income, and it will be difficult on her part to pursue the litigation here. And he has no money. What is there? He will go there. You go there. You want it in Morigaon?
Yes.
What? Why do you need to file an affidavit in reply? Huh? Why? Why do you need an affidavit? These are matters which should be finished up one day itself. We have already stayed the proceedings. Huh? This court have duly taken note of the service upon the respondent is complete. Mr. So-and-so appears on behalf of the respondent. Stop taking into account the above. This is a case of stay. You did not pay the 10,000, nah? But not your case. Not your. Taking into account the above. So Mr. So-and-so appearing on behalf of the respondent seeks for some accommodation for filing an affidavit in opposition. List this matter again on 19th of May 2025. The affidavit in opposition be filed by 30th of April. The petitioner herein would be at liberty to file the reply. Interim order passed earlier shall continue till the next day.
48.
Oh, this one, 10,000 rupees cost imposed. Now, have you done that? What is required?
We file an application.
Okay.
And
Ah,
you
I-
got to see a prayer portion. That
I
pays
see.
5.
You filed an IA.
Yes.
And why didn't you call for? Well, what is the number of the IA?
Wait a minute. Number minute. It was filed on 10/3.
10-3. Mr. Ghosh, you have received the copy?
Yeah. I have instruction to represent the name of the legal year time represent.
But without that, I cannot pass an order. In fact,
Is not there.
your petition is in the spirit of order 41 rule 20. It's not a petition in other, that when you are already made somebody a party who is there, but you have not made him a party, this court can very well. do it. Anyways, without the thing, you can't do it.
But my suit, my lord, from 2015, VW is not good.
Okay, let me list it on 26th.
Yes.
I intend to give them one chance for giving the evidence.
What
The re-
last 10.
No, Mr. Ghosh, I would have otherwise. But the problem is, when I saw the documents out there now, there is gross mistakes being committed by the court sometime or the other. We fix it for some other matter, this matter, that
No,
matter.
2015 order, which is challenged before this High Court, that was also dismissed. Prior to that order I have brought now.
No, no, our High Court has allowed them.
No, dismissed. This is the order. Well, dismiss, since it was a court is a precedent, so therefore the appeal, the revision stand dismissed. Appeal the order and revision stand dismissed.
By
By
High
the
Court? No, the High Court did not dismiss it. But there was some cost imposed, which was not.
court imposed by- or appeal. Sorry, what?
Anyways,
Against that, they
Mr.
have come.
Esdotto, the
That was
senior
dismissed.
counsel submits that the application, due application has been filed. To stop taking into account the above is the matter on 26th of March 2023, 2 p.m. To stop interim order passed earlier shall continue. You're hearing. What hearing? Anybody hearing? What hearing?
Second.
What hearing? I fixed it. I would never fix it on his birthday.
Not by this.
And I should not take up any more second appeals till I leave. Okay. Well, you both of you don't seem to be in urgency. No, you are in urgency. Okay.
Early hearing was allowed, early hearing petition filed by us was allowed in 2023.
I normally get sometimes enticed to have a look at the file, but no.
Any day.
The council's appearing on behalf of the party urgency in the matter, appearing on behalf of the respondent, expresses urgency in the matter. So taking into account the above, this matter on 22nd of April 2025.